Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen. Honorable Senators, I have granted leave of absence to Senator Brian Baig and Senator Vishnu Danpal, both of whom are ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, ORDT. By Her Excellency Christine Carla Kangaloo, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces, to Mr. Daniel Rashid. Whereas Senator Brian Baig is incapable of performing his duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the Constitution of Trinidad and Tobago, and in accordance with the advice, rather, of the Prime Minister, do hereby appoint you, Daniel Rashid, to be a member of the Senate temporarily with effect from the 27th of January, 2026, and continuing during the absence of Senator Brian Baig by reason of illness. given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 27th day of January 2026. To Mr. Sanjiv Boodhu. Whereas Senator Vishnu Danborn is incapable of performing his duties as a senator by reason of illness, now therefore I, Christine Carla Kangolo, President as aforesaid, in exercise of the power vested in me in Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Sanjiv Boodhu, to be a member of the Senate temporarily with effect from the 27th of January 2026 and continuing during the absence of Senator Vishnu Danborn, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 27th day of January 2026. Honorable Senators, Senators are required to take the oath. Can we all stand?
I, Daniel Rashid, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Sanjiv Boodhu, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Papers.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following papers listed on the order paper in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Children's Life Fund for the financial year ended September 30th, 2016.
Introduction of bills. The Copyright Amendment Bill 2026 in the name of the Minister of Land and Legal Affairs. The Civil Division Bill 2026 in the name of the Attorney General. Motions relating to the business or sittings of the Senate and moved by a minister.
The Leader of Government Business.
Mr. President, in accordance with Standing Order 31.5, I beg to move that the Senate agree that urgent government business take precedence over private members' business scheduled for today, and that debate be resumed on the second reading of the Law Reform, Zones of Special Operations, Special Security, and Community Development Measures, Bill 2026.
Honorable Senators, the question is that in accordance with Standing Order 31.5, does Senate agree that urgent government business take precedence over private members' business scheduled today, and that debate be resumed on the second reading of the Law Reform Zones of Special Operations, Special Security, and Community Development Measures, Bill 2026. Those in favor say aye. Those against say no. I think the ayes have it. Government business will take precedence over private members' business, and debate will resume on the second reading of the Law Reform, Zone of Special Operations, Special Security, and Community Development, and Special Operations, Special Security, and Community Development Measures Bill 2026.
Public business, government business, bill second reading.
Honorable Senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Friday, January 23rd, 2026, will be resumed. A bill entitled an act to provide for special measures for upholding and preserving the rule of law, public order, citizen security, and public safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters. Honorable Senators, let me advise, because we are now entering into what is called a marathon. We have had thus far some 24 speakers on this bill over the last 3 days of debate held on January 20th, the 21st, and the 23rd, 2026, respectively. The debate shall now be resumed. I recognize Senator Sanjiv Boodhu.
Thank you very much, Mr. President. I'm indeed grateful for the recognition permitting me to join this most important debate in our nation's history this afternoon, and I express my gratitude as well to the Honourable Penelope Beckles-Robinson, the opposition leader of this great republic, and to, of course, the leader of opposition business, Dr. Amery Browne, Senator Amery Browne, for the opportunity to contribute. I joined the debate today, Mr. President, not in opposition to law enforcement, not in denial of the seriousness of crime in Trinidad and Tobago, and not in ignorance of the real fear that many citizens feel in this country, in their homes, in their businesses, in our communities. I joined the debate, Mr. President, today because this bill asks us to do something far more serious than confront crime. This bill asks us fundamentally to alter the relationship that exists between the citizen and the state, between liberty and military power, between constitutional restraint and executive discretion, Mr. President. The debate at its core is about constitutional discipline, and it is because crime is so serious in Trinidad and Tobago that constitutional discipline matters most today. Our Constitution was not written for moments of calm. It was written for moments of pressure, moments when fear tempts us to trade liberty for the promise of order, Mr. President. The framers of our Constitution understood something very clearly, and that understanding was that the greatest threat to freedom does not arise when government is weak, which it currently is, but when government is angry or forms a belief that ordinary law is no longer sufficient. Section 3 of this bill, Mr. President, declares its inconsistency with Sections 4 and 5 of our Constitution, and we must ask ourselves, what powers are we normalizing and at what constitutional cost? And let's be clear and precise about what this bill does. This bill at Section 6 empowers the Prime Minister in her capacity as the Chairman of the National Security Council, and by her executive decision only, to declare any community within Trinidad and Tobago a zone of special operations, Mr. President. And within such a zone, the Prime Minister then has the ability to deploy a joint command, which comprises the police and defense force into that designated community. And while there, this joint command can establish cordoned areas, curfews, conduct stop, search, seizure exercises without a warrant, make arrests and detention without a warrant, and detain persons without charge, and present them to court subsequently within a period of time unspecified by the legislation, then for the court to determine whether they should be continued on detention, again without charge for a further period. That's at Section 18, subsection 2B of the bill, Mr. President. And all of this occurs based on that sole discretion by our Prime Minister. Sole discretion. Section 6 of the bill does not require the Prime Minister to consult with anyone or to be advised by anyone. It is later on, in a subsequent section at Section 7, where we see the Prime Minister required to consult with the Commissioner of Police and the Chief of Defence Staff, which relates to an extension of the period of time for that zone of special operations existence, Mr. President. Now, this discretion, we are asked to give that discretion to the Prime Minister that's on record for supporting extrajudicial unlawful killings of persons who are accused of drug trafficking without any evidence being presented for public consideration, without due process of law, without any attempt to arrest, intercept, or detain, without confirmation of whether these persons were within or outside of the territorial waters of any sovereign state. And most alarmingly, Mr. President, in the face of information that our own citizens were victims of these extrajudicial killings. These strikes, Mr. President, our own citizens, Mr. President, our people, members of our communities, our Prime Minister referred to our people when she is on record saying, kill them violently. So it is the same Prime Minister that will have this sole discretion to determine whether the military arm of the state should occupy our communities. The same Prime Minister who has no experience or training in policing, who's not practiced law for decades, the same Prime Minister whose government has imposed
Mr. President,
a continuing state of...
46-4, offensive, insulting.
I would advise that you kind of address your matter without necessarily and so on imputing or using language that could be interpreted as offensive. Continue.
Always grateful for the guidance, your astute guidance, Mr. President. So it is the same government that has imposed a continuing state of emergency in the country since July 2025, and to date that's some 194 days and counting. And it's the same government under whose leadership approximately 134 persons are detained at the ECRC, the Eastern Correctional Rehabilitation Center in Santa Rosa, and so many others like Miss Olive Jack, who remains detained without charge at the women's prison, those who are detained at Golden Grove and MSP, and who knows where else. And it really is impossible for us to separate this bill from the SOE, because the narrative behind the introduction of this bill, Mr. President, is that this bill is an attempt to secure, quote, the gains made. Because the learned Attorney General is on Hansard saying, quote, at the end of the state of emergency, it is important to have something in place to continue the gains made. The Honorable Attorney General also made reference to one Mr. Wayne Head, who warned that crime could surge if emergency powers are lifted without proper contingency planning. So all well and good. Except I ask the question, of the hundreds of persons detained under the SOE for close to 200 days by the 31st of January 2026, how many have been charged since their detention? My information, Mr. President, always subject to correction, is that less than 10% of the 134 men currently detained under detention, preventative detention orders pursuant to the State of Emergency Regulations 2025, less than 10% of them have been charged since their detention, Mr. President. And less than 10% of them have been interviewed by the police. Now, what is the significance of being interviewed by the police if you're in custody? Well, for the benefit, Mr. President, of the viewing and listening public, the way that policing is supposed to work and works in Trinidad and Tobago and any free and fair democratic society is that the police would either receive information or a report of a crime, or they would gather intelligence by some intelligence gathering exercise intentionally, and they would form a reasonable suspicion based on that information gathered. And they would make inquiries of the suspect. And very often, Mr. President, the police may interview a suspect even before that person is arrested. And in fact, where there is not even a direct report made by a victim, where the police are acting solely on information or intelligence, very often the police would solicit an interview with the suspect before determining whether to lay a charge or not, Mr. President. And there's a reason for this. The reason for this is because a suspect under caution quite oftentimes says something to cause the police to charge him or her. It is very often the words of the suspect himself that causes him to be charged. And those words are then used against him in his own prosecution. And that, Mr. President, is why we have caution, why we have fundamental rights to silence, a right to not incriminate oneself. And the right to silence, Mr. President, is, it is unfettered, it is absolute. It is a right that you can't take away from somebody. And it's because it is so important. And therefore, if it is that we understand that in policing, a suspect might aid the police in his own prosecution, well, wouldn't it therefore make sense to have interviewed at least half of these 134 people that are sitting down in ECRC? So, Mr. President, one must ask what progress really and truly has been made under the SOE, because it seems to us that notwithstanding each detention order setting out, as required by the regulations, the information possessed by the relevant Minister of National Security that causes him to detain the person in the first place. Notwithstanding that, the police are not acting in the interest of securing a prosecution. So How is it that we have 134 men here in detention and we are talking about gains after less than 10% of them are being pursued for prosecution? So what gains? What gains are we talking about when in the papers a couple days ago we saw that the murder rate is higher in January 2026 to that date than it was in January 2025? How many detentions can we look forward to that will lead to successful prosecutions, Mr. President? Or is it that the plan was simply to detain people for as long as possible? And if so, then how can we as citizens believe that this is a real crime-fighting strategy? Mr. President, this type of behavior is simply unsustainable, unjustifiable, ineffective. It is a danger to law-abiding citizens. And I mean, if we are detained as law-abiding citizens, we have under this SOE, we have no real course to justice. We've lost the presumption of innocence. We have lost the right to be told the reason for our detention, other than what is on the face of the detention order. We've lost the right to defend ourselves, and we have to wait until the 31st of January when the state of emergency ends. So considering all of that, how are we to believe that this bill is not going to be another arbitrary exercise of executive power unleashed on the citizens of Trinidad and Tobago? Sections 4 and 5 of the Constitution, Mr. President, this Constitution here, it does not include aspirational language. It doesn't include decorative language, Mr. President. It gives us justiciable guarantees as citizens in this country, Mr. President. Among those guarantees, a right to life, a right to liberty, a right to security of the person, a right to enjoyment of property, the right to due process of law, the freedom from arbitrary arrest or detention, the right to a fair hearing, protection, Mr. President, against the abuse of state power. But this bill, Mr. President, authorizes the Prime Minister to do exactly what sections 4 and 5 prohibit. It allows her the power of arbitrary detention, warrantless intrusion, and executive action without judicial supervision, Mr. President. And this bill allows the Prime Minister alone, not a judge, not members of Parliament who are elected by the citizens to represent them, not an independent Security Council, the Prime Minister alone to determine where a zone of special operations should exist. And this Senate, this Honorable Senate, as protectors of the citizens, is asked to approve the Prime Minister's ability to militarize civilian space without civilian safeguards. Now, Mr. President, I'll be the first to recognize the very hard-working and dedicated men and women of the Trinidad and Tobago Defense Force. These men and women serve their country honorably, with dedication, with integrity. But, Mr. President, let us make no mistake here today. These men and women are soldiers. They are soldiers. They are not trained in civilian policing. They are not trained in civilian use of force policy. They are not trained in evidence collection and evidence preservation. They do not operate under the same accountability structures as the police. And, Mr. President, to top it all off, these people did not ask for that training. The men and women who work in the Defense Force in Trinidad and Tobago, they made a conscious decision to become soldiers. They didn't ask to become police officers. So the facts that I'm talking about today is not meant to be an indictment on them. It is a statement of fact. And by way of example, I decided to be a lawyer. This is the profession I have chosen, and it is unfair to deploy me to conduct some medical procedure and then attempt to hold me accountable in law if something goes wrong. So that we mustn't pretend that this bill does not place soldiers into civilian communities with expanded operational authority, while simultaneously removing civilian legal safeguards that justify the force that is contemplated within the bill. Mr. President, the combination of these factors simply is dangerous. The combination increases the likelihood of lethal encounters. It increases the risk of unconstitutional and extrajudicial killings. It increases the probability of failed prosecutions and the failure to secure evidence. It increases the inevitability of constitutional litigation against the state. And these increased risks really can't be labeled as any kind of conjecture because there are historical facts internationally to support this. Mr. President, moving away from that, context matters when it comes to legislating. The country currently is in a state of alarm and concern arising most recently from the very unfortunate killing of a young man only 31 years old and the shooting and consequential paralysis of a young woman a mere few days ago via an interaction with the police. And I wish to pause, particularly on behalf of my colleagues, to extend condolences to the members of the Samaru and the Seeley families. These young people, as far as the public is aware, were not criminals. They have no criminal history. There's no criminal record. And video footage shows that Mr. Samaru surrendered with raised hands before being shot multiple times, Mr. President. That is the context I'm referring to when I say context matters. And what concerns me even more, and concerns the people of Trinidad and Tobago even more, is that the Commissioner of Police is quoted as saying on the 20th of January 2026, quote, "The occupants, instead of choosing to surrender, instead chose to challenge my officers, and acting in accordance with the use of force policy, my officers responded likewise. After an exchange of gunfire, 2 individuals were found nursing gunshot injuries." That's what the Commissioner of Police is on record as saying, as reported in the daily newspapers. Notwithstanding a very clear pronouncement that came from the TTPS, from the Commissioner of Police, that the police came under fire and they had no choice but to respond with gunfire. The public was then made aware of the true events of the actual shooting, and that was made aware to the people of Trinidad and Tobago via civilian camera footage, not police camera footage, not body cam footage, civilian private property camera footage. This entire incident is a real travesty for the people of Trinidad and Tobago, a travesty for those 2 families. Not only was a life lost, but a person is left paralyzed and children are left without a parent. And the TTPS is now shrouded in mistrust from the public because of this incident. So there are no winners in this situation, Mr. President. That is the context to which I refer. Yet it is against that backdrop we are told, give us more power, fewer safeguards, and less oversight. That, Mr. President, I respectfully submit, is simply not how trust is built. On the contrary, history teaches us that this is a recipe for further disconnect between the citizens and the police. And this is something that this Senate must avoid at all costs. The citizens cannot mistrust the police if we are to make any real progress in crime fighting, Mr. President. And so I ask the government to refrain from setting up the TTPS to fail. Refrain from setting up the police to fail by introducing this bill. Withdraw this bill and let us come together to enhance the law without removing constitutional rights. Let us recognize what we need is support for the TTPS to increase detection, to increase intelligence gathering, to increase prosecutorial strength, and to treat chronic institutional inefficiencies, Mr. President. That is what we need. And I'm sure the question will arise, well, what has been done in the last 10 years in this regard? Well, the former administration, Mr. President, worked hard to support the criminal justice system by introducing the AJIPA legislation, which removed a decades-long backlog of preliminary inquiries. And in the furtherance of that, the last administration introduced several masters to assist in moving criminal prosecutions through the system in a much shorter time, by providing a new court space at the International Waterfront Center for the Criminal High Court so that the Hall of Justice could accommodate more criminal assizes and more criminal judges, Mr. President. The last administration introduced anti-gang legislation and amendments to the Bail Act, introduced the Interception of Communications Act, and that is a very important piece of legislation because it specifically allows the police to go after the communications taking place between the prison and those on the outside of the prison, which we know facilitates the continuation of criminal activities even after persons are lawfully incarcerated. And the former administration did all of this while dealing with the rise in crime which came from the likes of live sport and similar programs which originated between 2010 and 2015, which facilitated crime and criminality of a magnitude never before seen in this country, Mr. President. The former administration acted decisively to address the leadership of the TTPS by appointing a substantive commissioner of police, Gary Griffith. And that was after some 10 years of not having a substantive commissioner of police before. So, Mr. President, I submit that there are many ways that we as legislators can collaborate to address the scourge of crime. But, Mr. President, to ask this Senate to give this Prime Minister the ability to unleash quasi-military occupation of certain communities is just unfair. In determining whether this bill is necessary and proportionate, Mr. President, we must remind ourselves that our Constitution was written for moments like this. When fear tempts us to abandon restraint, we must ask ourselves whether we govern by fear or by law, whether we protect people by defending their rights or by suspending their rights. This bill asks us as a country to abandon our duty to uphold our Constitution as a free and fair democratic society governed by law, due process, equality, and inclusion. And we must recognize and see this bill for what it is. It is an attempt to suppress certain sectors of our society, Mr. President. The same sectors of our society that have faced unemployment by the tens of thousands. The same sectors of society that have faced exorbitant taxes, putting them out of business. This government asked the Senate to authorize the Prime Minister to take away our rights, our voice, our activism. And that's the same Prime Minister who buff us and tell us behave, who say she gonna bust head, who say kill them violently, who buff for the Law Association, buff for the Energy Chamber, buff for local government workers, and buff for the independent senators in the Senate. That is governance by big stick, Mr. President. We on this side reject it. We reject suppression of rights. We reject the suppression of state abuse hurled and thrust upon the people of this country. We reject hiding behind this naked attempt to suppress voices, reasonable democratic voices in this country, Mr. President. Mr. President, I thank you very kindly.
Anybody else? The Honorable Foster Cummings.
Mr. President, I thank you for the opportunity to contribute to the debate on the law reform zones of special operations, special security and community measures Bill 2025. This bill, Mr. President, attempts to fight crime by suspending fundamental rights and freedoms. It seeks safety by weakening those rights and freedoms. It substitutes normal policing with exceptional force and constitutional protections with executive discretion. Mr. President, within the zones of special operations, it permits extraordinary measures, including warrantless searches, restrictions on movement, curfews, and enhanced security powers that would be unconstitutional in any other part of the country outside of the declared zones. History teaches us, Mr. President, that when states respond to crime by curtailing liberties, the long-term costs often outweigh the short-term gains. And, Mr. President, crime, or at least the approach by this current government to crime, emphasizes heavily on overstepping certain fundamental rights of our citizens. Now, I would be the first, having been exposed to a community that one might consider as a high-risk area and serving that community for a number of years, I have a full appreciation of what are some of the problems we face in this society. But the question is this the solution? Mr. President, the most telling feature of this bill is that it openly acknowledges its own constitutional infirmity. The bill expressly states that it infringes Section 4 and 5 of the Constitution, the very provisions that protect personal liberty, freedom of movement, freedom from arbitrary search, and the right to due process. As a result, it requires a special 3/5 majority for passage. That admission alone should cause the Senate to pause. Parliament does not lightly override fundamental rights, and when it does so, it must be satisfied that the infringement is strictly necessary, proportionate, time-limited, and supported by overwhelming national consensus. And so today the opposition questions whether that threshold has been met. The question we have to ask ourselves, all of us, as members of this Senate, on behalf of the law-abiding citizens of this country, is, are we prepared to sacrifice those rights where we live? Are we satisfied that in order to treat with the obvious crime problem that we have in the country, that we are okay where we live, that on our approach to our home, that community has been declared a zone of interest, special operation, and that there's a cordon in place, that we are stopped, that we are traumatized, that our family in the motor vehicle with us have to undergo searches, that when we get home with our young daughter or young son, that the police has the authority to enter your home without warrant, search and traumatize your family? Are we satisfied that we here as senators are prepared to make that sacrifice in order to treat with this problem? Because you see, as long as it is in Laventil or Morva or Maloney or La Hocketa or wherever we suspect that this special zone might be, we might be okay in voting for this legislation because it does not touch us. But the authority that we give to the government today through this legislation does not spell out for us today where these locations are. Tomorrow it can be right at your doorstep. And if you are prepared to say to your 5-year-old child, or your wife, or your husband, or your grandchildren, that you are giving today the government without the safeguards of a state of emergency, the power to declare any area, including around your home, as a zone of special operation, and giving these forces the right to do what this bill allows them to do, then you may feel comfortable placing that vote. Granting the state power to suspend constitutional freedoms within designated communities is one of the most serious acts this Parliament can undertake. It must never become routine. It must never become routine. It must never be driven by political expediency. We find this bill dangerous in its breadth and constitutionally troubling in its design, Mr. President. It concentrates extraordinary power in the executive, weakens judicial oversight, and risks normalizing emergency measures as a permanent feature of governance. Citizens observing the state of emergency, the extension of the state of emergency, were wondering whether this government would be spending its 5 years in office having a state of emergency in place in Trinidad and Tobago? Well, the answer is here. In order not to have to do that, the government has brought this legislation not to utilize the same safeguards as a state of emergency, but to say that within the executive, that the Prime Minister will have the authority to declare any community within Trinidad and Tobago as a zone of special operation. Not that the Parliament will have the opportunity to debate the matter if it has to be extended, but that power to extend will also rest with the Prime Minister. And we will get the courtesy of a statement with regard to declaring a particular area a zone of special operation. Mr. President, once a law announces that it will operate even though inconsistent with sections 4 and 5, the public must understand what is at stake. Those sections protect, among other things, personal liberty, security of the person, enjoyment of property, freedom of movement, privacy, and the protection of the law. So when the government says, in effect, that this bill will operate even if inconsistent with those rights, what it is really saying is that within a declared zone, the ordinary citizen may be will lawfully be subjected to measures that would be unconstitutional anywhere else. Now, something as fundamental as this, I would think, should be told to citizens before, so that they understand what yellow is the code means. I would imagine that when you are campaigning to ask the citizens of Trinidad and Tobago for their support to enter the corridors of power and take control of the executive, that you would say to them, coming very soon in our attempt to treat with the crime problem of which all of us are concerned, is a bill that will allow us to declare certain areas a zone of special operation, where you will no longer enjoy the rights that are enshrined in the Constitution to protect you as a citizen from abuse of power and otherwise. And this could be anywhere. This could be Kakandi in Felicity. This could be Siparia. This could be Point Fortin. This could be Glencoe. This could be Westmoreland. This could be Valsayn. It can be anywhere in Trinidad and Tobago, Charlottesville, Lansfomie, Speyside, Couva, Mason Hall, Diego Martin, Mbakade, Gulfview, train line, anywhere. Nowhere, anywhere in Trinidad and Tobago, Mr. President. The bill confirms, Mr. President, it empowers the Joint Command to establish cordons and impose curfews. We all have our history in this country about curfews. For those of us who experienced the 1990 experience, for those of us who were around during the pandemic, experience the situation of the inconvenience of curfews. It allows for extraordinary search and seizure powers, Mr. President. It provides for arrest and detention under a special regime. And we know that Senator Boodhu gave us some facts about detentions right now and those persons who are currently held in detention. Mr. President, take freedom of movement. The bill contemplates curfews that confines residents and restrict movement within their own communities. This has a profound interference with ordinary life, with work, with school, with family obligations, with worship, with medical care, with attendance to parliamentary sit-ins. So it then falls to the police officer on duty for you to explain to them what your emergency is that requires you to move freely within this zone of special operation. And if they don't agree, I don't know what recourse you have, but to possibly be detained or returned to your home. We would like to think that sometimes when particular powers are given, that all persons act with due care and attention. But we have seen, not too long ago, that immediately a particular policy position was taken. The emphasis shifted from crime solving of any other kind, and it appeared, it may not be so, but it appeared to citizens that traffic violations became the #1 priority. So that when the fines were doubled, when it moved from 12 to 24,000, and 5 to 10,000, and 1 to 2,000, when those things occurred, there was an excitement in the population, and persons responsible for upholding those matters took their job very seriously and took the streets urgently to attend to citizens who were in violation of those particular areas I mentioned. It turns entire neighborhoods into controlled spaces where the citizens' right to move freely becomes subject to executive design. Take protection from arbitrary search and privacy. The bill provides for search and seizure powers exercised without the normal safeguards that citizens may rely on. In a zone, residents can expect heightened stop, searches, and intrusions. Mr. President, the government may argue that these are necessary tools for extraordinary time. I am not for 1 minute downplaying the importance of detection of crime and for the police to be given the authority and all of the resources to do their job. But it does not stop there, Mr. President. You are simply putting a plaster on the wound, because after that period of 180 days, what happens next? How are you getting somebody criticized a speaker for speaking about the root causes? How do you treat with these problems in these communities if the government does not simultaneously say to this parliament and to this country, we understand that there is a problem, we understand that young people are short of opportunities, and therefore we are going to take and place the investment to make sure that after you do this, so if you want to call it clean up, that there are opportunities available for the young people instead of playing politics. The last government formed the Ministry of Youth Development and National Service. And Mr. President, I had the privilege of serving as minister in that ministry, so that I can tell you firsthand that in addition to the work of the Ministry of National Security, at this particular ministry, the executive decided to pay particular attention to youth at risk. So the category of youth referred to as NEET, N-E-E-T, which suggests that they are not in any formal employment, they are not in any formal education program, or they have not been exposed to any particular training to equip them for the world of work or for small business. And it's no secret that throughout this country, we rolled out significant programs to give young people that second chance. Mr. President, I visited Barcelona Street recently in East Port of Spain, where it's a community that you may consider at risk, where we refurbished a facility to allow the young men and women from that community who may have difficulties going out of the community for training because of the crime situation in their community or because of economic circumstances where they cannot afford to move to another established training facility. And it pained my heart to see that facility locked up and no plan, nothing in the budget for operationalizing a youth training facility at Basel Street, nothing in the budget for operationalization of a youth training facility in Laventille, nothing in the budget for operating the youth facility refurbished in Malik, nothing in the budget for the youth facility in Point Fortin, nothing in the budget for the youth facility in Palo Seco, nothing in the budget for the youth programs in California, nothing in the budget, Mr. President, to treat with youth development programs and certification for young people so that they can have another chance in life, so that they can prepare themselves for work, so that they can get involved in small business, so that they cannot be so accessible to the criminal element in some of these very communities that the government would like to utilize this legislation for. And for those young people interested in business, Mr. President, we went further. We established a small business grant of $20,000 because we understood we were training and exposing them to certification in particular skilled areas. And then those who could not find employment or those who had a direct interest in going into business, through NEDCO, the government allocated $50 million through a loan. And that program, operated by NEDCO, took these young persons into a short-term training program, exposing them to small business operations, how they can keep their books, how they can develop a business plan. So for instance, if you were exposed to a tailoring program, at the end of that program, you'd need a serger, you need a sewing machine, etc., to set up your small operation, your cottage industry. And instead of, since you can't qualify for a loan, you may have never worked, instead of exposing them to a loan, a small business grant of up to $20,000, that would put young people to work right away to earn a living. It has been scrapped. The money allocated to that program has been moved back to the Ministry of Finance. All of the employees have been sent home, and we have heard nothing about support for the entrepreneurs who want to get in business at that level. I have not heard from the Ministry of Agriculture, however, that they have scrapped the grant of $100,000 to farmers who can access similar grants. I've not heard that at all. No scrapping of the agriculture grant of $100,000. But the small business grant of $20,000 has been summarily dismissed and scrapped by the government. Mr. President, I like the idea that a part of the bill speaks about setting up of this community development, what is it called? There's a committee that is supposed to treat with some of the points I'm raising now. But for the committee to be more than a talk shop, the bill needs to give a bit more teeth. It is called the Social Transformation Committee. And while I'm treating with that, Mr. President, I note that there are several ministers allocated to serve on this committee. I'm not seeing the Minister of Youth and Sport, and maybe that is an oversight on the part of the government, because young people are the heart of the problem we're discussing, and therefore I would think that the Minister of Youth and Sport should be someone serving on this committee. I see as well that at G, it speaks of a representative from the ministry with responsibility for social security And then, I don't know if this is a duplication, at M, it speaks about a representative from the ministry with responsibility for social development. So I don't know if there is a difference or if it is a duplication. I would ask the Honorable Attorney General to take a look at it and see whether that is not something that requires some level of correction. Mr. President, our Constitution already provides a mechanism for occasions of national crisis. Section 7 exists for a reason. It contemplates a formal declaration, a limited duration, parliamentary supervision. It requires transparency and accountability in the use of exceptional powers. This bill sidesteps that framework. Instead of a constitutional emergency procedure with built-in checks, the bill allows the Prime Minister by order to declare a zone in 2 specified circumstances. It permits the Prime Minister to revoke a zone at any time. It allows zones to operate for months with the possibility of an extension. And it does so without requiring immediate parliamentary approval of the initial declaration. Parliament is to be informed afterwards by a statement within 14 days. Mr. President, this should alarm every senator regardless of party affiliation. Because the bill does not have a sunset clause, you know. And sometimes, while in the executive, some may delude themselves that they're going to be there all the time. When you make law for today and for tomorrow. And some previous speaker mentioned that you never know who may sit in that office sometime to come. And this bill has several areas where it can facilitate excesses by the executive, Mr. President. Because once we normalize exceptional powers through ordinary executive orders, we create a permanent pathway around constitutional safeguards. We create a state of emergency in fragments applied to selected communities without the full constitutional discipline that emergencies demand. That brings me to the question of proportionality and justification. This bill invites the suspension of constitutional guarantees in a community for up to 6 months at a time, with extensions possible. This is, in fact, what one would consider an extreme measure. So I ask the government plainly, has the government proven that our current circumstances warrant such an extreme remedy? Where is the case that existing law is so inadequate that we must override our supreme law? Mr. President, exceptional power should never become a substitute for sustained governance. There's a responsibility that a government has to offer good governance to the country. And every issue, no matter how serious it is, cannot be addressed or solved in this way. Crime is not reduced overnight, and it is not reduced by declarations alone. It is reduced by slow, difficult work of strengthening institutions, building intelligence capability, maintaining community trust, supporting effective investigations and prosecutions, and ensuring that witnesses feel protected enough to come forward. It is also reduced by consistent social interventions, particularly for young people who are most vulnerable to being drawn into community activity. Yet, this government, in its last 9 months, I am hopeful that it will be addressed in its months to come. It's early days yet in the government, appears to have withdrawn any effort towards serious youth development. Programs such as the Civilian Conservation Program has just been scrapped. The Youth in Agriculture programs, scrapped. The several youth facilities that are completed, unopened. The several training programs through UTT, ECIAF for the agricultural programs, the several skills training programs that we were given to young people from these very communities free of charge and courtesy of the government, all of these programs have been stopped. And what have we replaced it with? We replaced it with today asking the Parliament to approve, to give the executive authority to suspend the rights of citizens to go into these communities, restrict movement, search without a warrant, arrest, detain, seize. And at the same time, we are not prepared to see what investments are we going to make in these communities to give opportunity and hope to the citizens residing in the same. Mr. President, the reality is that extraordinary powers may suppress symptoms of crime for a time, but they do not rebuild the foundations that make communities resilient. That is why this Parliament must be careful and must be cautious. We must ask whether we are responding to crime with the full range of tools available to the state, because the state does have at its disposal the ability to impact these communities positively, and whether we are placing disproportionate weight on coercive measures because they are the ones most visible. Is it that we want to make sure that we are saying we are doing something about crime? It is like the stand your ground legislation, where there are still persons in this country that feel it is okay to draw their licensed firearm and shoot after the individual running out of their yard because of that legislation that was passed, and not understanding that they still would be subject to the law before the courts of Trinidad and Tobago. Security is not achieved by power alone. It is achieved by balance, by continuity, by discipline, and by strengthening the systems that prevent crisis from becoming permanent. Mr. President, the bill also raises serious concerns about the implications for Section 5 rights, particularly due process and liberty. The bill creates a special detention structure in which ordinary liberty is constrained under extraordinary authority. It allows the state to place citizens under an intensified coercive environment that then rely on procedural steps to argue that the due process is preserved. The risk is that the exception becomes the norm, and in a declared zone, the practical reality may be prolonged disruption, repeated stops, repeated searches, fear of movement, fear of gathering, and a sense that citizens' rights depend on where they live. Mr. President, it is well known that there are many businesses that will be interrupted by such action. There are many workers whose ability to go to and from work that will be interrupted. If a curfew is imposed in particular areas, there are certain businesses that will immediately be shut down because they operate after a particular hour. We must be honest about how power operates in real life. When communities are under occupation-style operations, the imbalance between citizen and state grows. Even lawful safeguards can be difficult to exercise. Accessing counsel, seeking relief, making complaints, all become harder when people are living under cordons and curfews and constant security presence. The bill itself recognizes this reality by requiring complaints to be recorded in the station diary, but a recorded complaint is not the same as meaningful redress. And that returns us to the most consequential constitutional issue of all, the deliberate use of Section 13, the special majority override. By relying on that mechanism, the government is asking Parliament to suspend citizens' normal protections on the promise that it will improve security. So in other words, you know we have a crime problem. You know it might be rooted in particular communities. No matter the fact that you are a law-abiding citizen, that you operate within the law, you are now being asked to give up those rights in order for the state to be able to apprehend the so-called criminals within these communities. Is it that under our current laws that is still not possible? One member on the government side spoke about how successful it was sometime in 2017 or 18 when a particular community, namely Enterprise, I don't think he called the name of the particular community, but Enterprise, where he referred to it and said certain type of operations, ZOSO operations, were successfully executed. Is it that the police, under the current circumstances, does not have the right, utilizing its intelligence, to seek warrants and enter the homes of those persons who might be involved in criminal activity, and do the same thing that this bill will allow them to do, except that this bill will also place a significant burden on all of the citizens living within that zone? Because, Mr. President, every encroachment on fundamental rights, even in the name of public safety, sets a precedent. And then this becomes the tool that the police must use to solve crime. That without this also, they will not be empowered to do so. Tomorrow, it could be any community deemed inconvenient. Mr. President, we do not accept that the solution to crime is the suspension of constitutional rights in this country. We do not accept that this is the solution. And even, you know, Mr. President, I come from a business family. Some people don't like that. But I come from a business family, proud to. I'm as proud as anybody else who's proud of their ethnicity. I'm proud to be coming from a business family. And at one of these business places, it is a normal custom that if something happens in the community, that because CCTV footage is in place, the police will come and ask for access to the CCTV footage. And in the last 25 years, there's been no occasion on which the management has said no to the police. Because you're all interested in assisting the police in doing their work. But then the politics steps in. I was in this parliament a couple of weeks ago when I looked at my phone and saw a message that the police, all 18 of them in a maxi taxi, heavily armed, had moved into one of these business places on a warrant. What was the warrant for? To access CCTV footage. 18 policemen heavily guarded. And at the same moment that I received that message from the management there, a member of the government on the other side was mouthing to me that there's police in your business place. At the same time. How could that be possible, Mr. President? And therefore it causes us, we must consider, when you put this kind of authority in the hands of politicians, when you put that kind of authority in the hands of politicians who are prepared to use it in this way, it has to be of concern to us. I have a copy of the document. I'll share it with the public at any point in time. But what was it intended to do? It was intended to create political drama. It was intended because they prevented business customers from going in, asked the customers who were there to leave, and caused a political drama to have some shadow. And that type of activity must cause us pause. in this country, Mr. President, there are people in the government actively urging people in the police to take action against members of the government on all sorts of frivolous issues. Members of the opposition, sorry. And therefore, when we pass legislation like this, we must take concern. Yes. We must have concern, Mr. President. And so, Mr. President, on behalf of all the right-thinking citizens of this country, on behalf, the Senate is not here. The purpose, the reason why we have this type of legislature is not to rubber stamp policy positions of the executive. The executive was elected and quite properly must come to the parliament with policy positions. That is the job that the executive was given by the citizens of this country. I have no criticism of the government for coming with a policy. What I hold true to is that the fact that you have the executive, you have separation of powers, and the executive must come to the legislature to enact legislation. Every senator in this parliament has a right to look at his legislation and give just due to the oath that they swore. Conscientiously serve the citizens without fear or favor. And so today, Mr. President, while I know, in winding up, that we do have an issue with crime in this country, that we do need to have opportunities in place at the committee stage, I intend to raise an amendment, that we do have urgent need for the government, just as urgent as bringing this legislation, to invest or to indicate to this country what are the steps that they're going to put in place for youth development in Trinidad and Tobago, and stop hiding behind audit and audit and audit to shut everything down. If you find a problem, you are in government, deal with the problem, but just as you have denied the citizens, the young citizens, access to the lands in Chatham, you have not denied the former colony workers the lands in Couva. I rest myself.
The Honorable Minister in the Ministry of Housing, Science and Roberts.
Thank you, Mr. President. To hear PNM talk about trust and lecture us about trust, PNM and trust is an oxymoron. The people do not trust the PNM. That's 2813, April 28. The people do not trust the PNM, 15-0 in Tobago. The people do not trust the PNM. Half a full Queen's Hall for 70th anniversary. No shame to come here and talk trust. The people have dealt with y'all because they do not trust y'all. That contribution by the Honorable Senator from the PNM and all the other contributions from the PNM are not oxymoronic, they're just simply moronic. I have never sat here and heard more nonsense. Imagine a senator quoting from the Constitution, Section 4, and all of a sudden he believes that he leaves out
Mr. President, Standing Order 46-4. The member is using unparliamentary language to describe other members of this chamber.
Just guide me on the language that was used.
Describe contributions as moronic.
Yeah, but is that moronic? I haven't seen that anywhere. Overruled, let's go.
Mr. President, for my honorable colleague, I withdraw the word moronic. It's vacuous, asinine, and ridiculous. The Honorable Senator Foster Cummings, who talked about trust, I do not even trust that the Honorable Senator wrote his own contribution because he was reading there, and we know that he has a proclivity towards plagiarism, because while he was reading that, he read the Constitution, Section 4. He quoted all the rights. This document is not designed vacuously.
46.4 and 46.6.
Yeah, I think I want to sustain that. So please, if you want to raise the conduct or you want to raise anything on the put, let's deal with it properly. Cool.
It's just happened to you, but I will move on. That's en passant. But anyway, the honorable senator quoted from the Constitution, Section 4. But just by mistake, he left out the first right. He read and he told us about the right to liberty, to security of the person, enjoyment of property. But he left out the first one, and those who have a copy, take it out. The first right enshrined in this Constitution is Section 4A, the right of the individual to life. But you leave out that and read all sorts of things, because that's the dishonesty of the PNM. The right to life. You can disturb me, boy. $500 million cannot make me harsh. So now they understand that the dishonesty of them. We are here to debate life. We are here to stop the bloodshed. We are here because of the failure for 10 years of the PNM to institute anything and any institution to keep our people safe. He spoke about the ordinary life in communities that are at risk. What is that ordinary life? Because we live here. I don't know about them, but I live on the ground. I could go anywhere, sit down anywhere at any time, whether Mango Rose up in Malabar, Carapo, down in anywhere down on the train line, and sit down and talk with you. That's what I do. So I don't know what they're talking about. The ordinary life of people in these communities that they are all of a sudden saying that the police presence will be such a dramatic a manifestation of oppression in these communities. They do not understand. People are under oppression right now. They're under siege. They cannot move. They're afraid of their children. They cannot play football in the street like we used to play and stub with toe. They cannot play cricket. They cannot come outside. The gangs have overtaken these, and for anybody to come in the Senate and bring this disingenuous argument that safety and security will stop ordinary life in these communities is not life at all. It is closer to death. And to hear people who live in gated communities, behind armed barriers, with security in boot, with community comfort patrol paid for, with armed security driving around, with air horn and CCTV cameras locked away, with police patrol. People who live in those communities saying that people in other communities would not want that. How come? So if you want it, why they wouldn't want it? Why the nurse wouldn't want to walk out on the road and see police officers and see security when she's going to take a car to go for an early morning shift? Why would she not feel secure? Why must she go out there and be afraid? Y'all come here and y'all talk like we inside some air-conditioned building with nice suit, but y'all don't live and talk reality. It was hard to sit down for 3 days and hear some of these arguments. It is so ridiculous to hear the Honorable Senator Foster Cummings of the PNM talking about he was there and he did so much. He gave the children an opportunity to get a $20,000 loan to build a business. Why you didn't take the $20,000 and give them the $500 million? He said people are running down things that are vexatious and frivolous. Yes, frivolous. Corruption, 4.1 million, venture credit union, no procurement, businesses of a man who says he swore on the Bible to take care of the country and he took care of himself and his family, talking to us here about opportunities for the youth. You know how much opportunities the youth's gonna get with $500 million? Then they brought
Mr. President, I rise on Standing Order 46. 4 and 6. The senator is imputing improper motives.
All right. Honorable Senators, I would say that if you want to raise matters concerning the conduct of any member of this House, let us do it properly. Okay? So just be guided.
Thank you. Then we move on to Senator Faris 2.0. Senator Boodhu came to say and talk about the rights, the constitutional rights and the freedoms and the process. Well, I want the 624 people who were victims of murder to read your contribution later this evening. When they could do that, then you could eliminate the number one right, which is the life, and stop the bloodshed. There were 624 murders in 2024, the last full year of your government, and you come in here to preach about what we should do and how we should give the judiciary resources. You are a lawyer. I used to have such great respect for lawyers. I thought lawyers had to be brilliant, amazing, study hard, diligent, analytical. And then I listen to these PNM lawyers, and I know any dum-dum could be a lawyer.
Except on this side.
The law reform zones of special operations, special security, and community development measures, Bill 2026. It's not about games. It's about keeping our people safe, keeping our children safe. I now get into some of the contributions from before. The Honorable Senator Candace Jones-Simmons. It's the first time in my life, Honorable Senator, that someone has told me to my face what I am listening to and what I am not hearing. I did not know that. But let me say that I listen to everything, every word and every point. And it's a bit disingenuous for you to tell me what I'm listening to and I'm not. You do not know. You cannot know. So I assure you that I listen to everybody's contribution. They were from, I don't know, I didn't want to say that part, but I would say it because I'm in a good mood. Maybe the Honorable Senator knows what I am listening to while I'm sitting here quietly listening, because maybe she spent too much time in Tobago in a red jersey. Maybe it is that, I do not know. Now, 48 out of 64 years, the Honorable Senator said that we should talk about...
Mr. President, Standing Order 46.6. That is a clear imputation of an improper motive.
No, overrule. Continue, please.
I don't know, they feel like they disturb me. You must know who debating. You could get up and down like Jack in the Box whole day, do squats. Maybe he didn't go in the gym, but he have a time to talk after. But I would also say to the Honorable Senator, you talked about zones of opportunities. But you see, life doesn't begin when a PNM president appoints a president senator and you come here. Life begins when you take interest in what exists. Because if you know about opportunities, you would know that that government, that PNM government, between September 2015 and April 2025, you don't want to know what opportunities they cut? Let me help you. The PNM cut sport funding from the NPI vote from 140 million down to 10 million. That's less opportunity. They cut Football Pro League, less opportunity, from 18 million down to 3 million annually, less opportunity. National Super League, they cut all the funding for the youths and them to play the football, less opportunity. They cut PAN in schools. They cut Panorama stipend from 1,000 to 500. They cut prize money for PAN. They took PAN man land away from PAN man. They rent PNM Minister building for 50,000 more than what they were renting an ex-man building for. They cut sport camps for 20,000 young children every July, August holidays. They cut that for 8 years. That's a zone of no opportunity. That is PNM. So you see, when you come to debate, you must know what existed, what was there, what opportunities were taken away, and where we are going. They cut funding, they're stopping there now. They cut funding, and those sport camps included the differently abled. If you talk to the differently abled and the communities of Special Olympics, they will cry for those sports camps with great coaches. They cut the sport development officers at the Ministry of Sport. 75 of them used to go around the country teaching, identifying talent, injecting discipline, building self-esteem. They cut that. You are not aware. They cut the sport caravans that were going around between 2010 and 2015 in rural communities looking for talent, coaching, putting science in it. You didn't know that. They cut school feeding from 76,000 breakfasts, and them like breakfasts, but 76,000 breakfasts and 76,000 lunches under Tim Gopi Singh. They cut that down before COVID to 48,000. Them cut food in children's belly, and you come to tell us about opportunity. We are aware, we are involved, and we will fix it. They cut funding to UTT. They cut out programs in UTT. They cut and closed down 5 MIC centers, closed down 6 NESC centers. Were you aware of that? They cut baby milk grant to feed children, right? Baby milk, key generation, cognitive development, fats, lipids, and so on, so they could be intelligent. Them cut that from poor people. So don't come and preach to me about zones of opportunity. The opportunity arrived on April 28th because we got rid of the PNM. We want to diversify the economy. Did you know they closed down THTTI, that's the Hotel Institute? So they want to bring sandals, but there are nobody to walk in the sandals. So it's best we wear slippers. They closed down Nursing Academy in El Socorro. That was built by Kamla Prasad Visesa and transformed by the Ministry of Youth. They 3,200 nurses between 2011 and 2015. They closed that down. Lack of opportunity. They cut food card. Food for people from 42,000 in September 2015 down to 18,000. You see, you didn't know. I know you might be bored, it might hurt you, but when you come to debate and lecture, you have to research and have information, or else it becomes oppressive and people have trouble listening. But I listen good, you see? I heard everything you said. They shut down Petrotrain, well, all them jobs that went, you know that? So therefore, I would then move on to another point. And I thank my brother, I forget his name, but he's on a blog, Opinion Box, because the next thing some of you all senators said, but this stigma. These also, if you put security in an area, it will stigmatize the community. Okay. Well, let me read from an article, Sean Douglas, Monday, 24 June 2019. The headline is, Prime Minister in 2019, who was that? Keith Christopher Rowley. He says the Coast Guard will run the Laventille pool. Let's hear what this honorable PNM Prime Minister said about the people of Laventille. Since this government is trying to protect people, and all of a sudden now, we're going to create, manufacture, endorse, encourage a stigma. Let's read. So the Prime Minister is sitting down there, the former, and the former next to each other, right? The Prime Minister said the new Laventille Community Swimming Facility will be run by the Trinidad and Tobago Defense Force, the Coast Guard, and the Trinidad and Tobago Police Service. And so it will be secure. Rowley said, Laventille had been so stigmatized by indiscipline and violence that the new pool would within 3 months be taken over by frogs and be full of green water if not properly run. That is a Prime Minister of the PNM talking down to his constituents and telling them that they are no good. They are not worthy to run a pool that is a little cheap 25-meter, 6-lane nonsensical pool. That they're not worthy to run it efficiently. Then he ran it into the ground and frogs went in it because he did not give the resources. That is stigmatization. That is when your leader tells you that you are no good. And what? Because he looked like them? That's the most disingenuous, ridiculous, uninspiring statement made. And that was the PNM. That's what they do. That's how they keep their communities. And now you're saying that me and this government on this side would stigmatize people. We are here to uplift all people, provide opportunity and safety for all, not only some. Rowley continued, it requires management and discipline and inputs from the Defense Force, the Coast Guard, and the Police Service to ensure this is a safe neighborhood. Avoid conflict, said Rowley, and fights, so this would not be an unpleasant place for your children. Rowley promised to instruct Finance Minister Carl Mimba to allocate extra funds to the Defense Force. Where the funds? Zone of opportunity, zone of lies of the PNM. They did not give any funds. The pool has been down for 18 months. Frog in it, the children cannot swim. It was closed on Friday at 4 p.m. till Monday 8 a.m. anyway. So a nonsensical waste of money and games played by PNM or with people's lives. We don't play game with people's lives. We come here to save people's lives. Things not perfect, but we're not allowing people to die just like that. The Prime Minister reckoned he could count on everyone to make sure the water stays clean and the facilities open. I can't read that, I just laugh. And that was a PNM Prime Minister. They have no shame to come here and talk in the Senate. But I could tell you, the United National Congress is powerful, and I know that. I know not only from the victory in the election, I know it because every time I sit down here in the Senate, I see a UNC reject make it to the elite in the PNM one time. We pelt out Lalale, he's a PNM senator. We pelt out Obika, he's a PNM senator. They never had nobody. So our rejects is them best. That's why they're on that side. Imagine I just sit down and listen to the son of Njak praise the PNM. The son of Njak, Geddes Granger, Macandal Daga, and all the brothers who were fighting for equality of black people. They were fighting against who? PNM. Who was the government from 1956 to 1986 unfettered? PNM. Who was the 1970 Black Power Revolution? Who that was against? PNM. The PNM. And they come in here like they want to rewrite history. I wouldn't bother with him, but I really know why we rejected him. His contribution was quite pathetic. Senator McNish, I would tell you that I agree with you. The PNM is a zone of failure, whether Anaconda, Baghdad, Sleepy Hines, whatever you want to call it, total, complete failure because they are only about policies of superficiality. So we agree. So this is not the be-all and end-all, but as we said, this is a suite of legislation and practices and implementation that we will attack the most heinous criminals, the most heinous oppressive situation. So we agree with you. But the COVID lockdown and so on, yes, that cut down the crime situation, but we do not expect that this will be forever, because as we get involved, as we realize that we have to rebuild the treasury that the PNM vacuum out, they didn't pay their bills, and now they come here to say, we are desperate to generate revenue, when all over every ministry you see, $1 billion wasn't paid here, 450 million here, 850 million. We will handle that, and simultaneously, we will recoup money to invest in young people and give them the opportunities that were taken away from them by the PNM. Well, Senator Dan Ball, I know they have a virus going around, but the virus brought the PNM even lower down because they brought Senator Boodhu to replace him. But Senator Dan Paul was a permanent secretary in the Ministry of Finance and a Minister of Finance for Akobo Sweat for 1 month. But yes, he came here and regaled us with a fantasy about Dudas and the IMF, and that this was somehow, some way, a methodology to bring in the IMF. It is so nonsensical, so fantastical. You should have go movie, tongue and paper to watch Avatar rather than to come here and talk that kind of nonsense. He talked about 2011 statistics, but we in 2026. That is the PNM. They are back in times. Them still believe Dr. Williams alive. He implied that a central hotspot, but it wouldn't happen. Wherever the hotspot is, wherever is needed, wherever citizens need safety and security, and they are crying out for it, they will get it because everybody deserves it. Well, I love carnival, I love mass, I love pan. As a Douglas, I don't have too much rhythm all the time, but that's okay, because the African part does go to the base and the Indian part does go to the heights, and sometimes you get confused, but that's okay. Carnival is about everybody. But to hear Senator Dan Paul, who I never see no carnival ban no way, telling me that the all-inclusive experience led to people coming down the hills to rob people is abject, total fallacy, nonsense, and concoction. He then tell me about some rapper called Furious Five. I don't know where he came out from at that time. Senator Michael de la Bastide. So, I heard you and you said you like debate. So I too like debate. And you came out quite scathing. It looked like your feelings were hurt by the words of the Honorable Prime Minister. And you took great offense. And you came out to ridicule the Honorable Prime Minister in your contribution and laugh at some of the words he used. But let me assure you, first and foremost, sir, that the Honorable Prime Minister has a mandate from the people of Trinidad and Tobago. She received, in order to take care of this country and to promote her policy for safety, security, and economic diversification, 358,000 votes. With all due respect, sir, you were selected by a PNM president and you did not get any mandate. You were selected by one human being. You cannot believe for a moment that a prime minister who has the endorsement of 358,000...
Mr. President, Standing Order 46.8.
I don't think we should bring the president into our debate. Okay.
I agree, sir, because the president will be ashamed that he is a PNM, so I agree with that. I withdraw. So the problem is that we must understand the assignment, because the mere fact that a president senator selected would be so emotional, so hurt because of some words from a prime minister who has a mandate and whose job it is to ensure that she gets and fulfills her promises made to the people, it shows that somewhere along the line, we've lost the script, we've lost the plot. Because if a prime minister brings legislation here on the backs of 358,000 votes, it is quite arrogant for one person or 9 people selected by one person to believe that there is some sort of equity in a democracy. And if you read the Constitution and every institution that we have, the preponderance of power and essence of legitimacy comes from the mandate of the people. The voice of the people is the voice of God, and the voice of the people says, we elect Kamala to keep us safe. We elect the member for Superior to keep us safe. So anyone who does not have the maturity to understand that, hear those words, listen to them, absorb them, and not get emotional, then maybe you have taken a position that you're not suited for. And just let's be clear, because there was a statement being made that the president's senators are somehow independent. No. There's only 2 presidents that were active politicians in our history where there was a vote or it was a contest. That was A.N.R. Robinson and the now president. This president was elected only by the votes of the PNM. All others, from Ellis Clark, Noor Hassan Ali, George Maxwell Richards, Anthony Carmona, Paula May Weeks, were unanimously selected by the Electoral College, and therefore an impression or a perception of impartiality was there. But that does not exist in this case. This case, it was a partisan vote. One side voted for the president and one side voted for Israel Khan, who lost. So to think that somehow the principles of apparent bias, conflict of interest, and so on fail to apply because you all determined that it doesn't, doesn't sit well with me. The principles apply to any and everyone. And if you are selected by someone who has a proclivity or affiliation or an intimacy with one side, it is reasonable to think that you too may have that. You may not actually, but we're not talking about actual bias. We're talking about apparent. And then if we go further, we could even investigate actual. So if an honorable prime minister makes this point,
For the first time in the entire time that I have been in this Senate, I wish to take a point of order. In fact, several. Section 46.4, Section 46.6, Section 46.7. Not only, I think the most opposite one is 46.6. No senator shall make an imputation of improper motives against any member or an offensive reference to a member's private affairs. There's a clear imputation of an improper motive on the part of one of the independent senators on this bench, and I think that that is out of order, and I ask you, Honorable President, to direct the members speaking accordingly.
All right, I think I'm going to sustain those points, and I'll ask my colleague to just come back in back.
I forgive the member, she was not here. I'm just responding to a discussion and an argument proffered by the independent senator. I did not impute any improper motive, so I'm not understanding if my English is not clear. I am speaking about simple principles. I'm speaking about simple principles. And Mr. Tight Pants, if your brain is not getting oxygen, you could sit there and be quiet. So we continue.
Please. Let's, hello, I'm on my legs. Please, silence. Let us not get into personal bantering, please. It doesn't help. Please, continue.
Thank you, Mr. President. But the point that I'm making is, Honorable Senator said, for example, that we did not consult. And he went to great pains to say that we were irresponsible, disrespectful, and that we didn't come to consult. But I put it to you, Honorable Senator, that our entire job involved consultation. You are selected. We walked this country for 10 years. We walk the hotspot areas. We talk to people in the thousands. We have consulted for 10 years while the PNM ravaged the treasury and decimated our country and our economy. We have consulted. We have asked the people for their mandate. And the policies of Kamla Prasad Bisesa are based on that. We did not sit for someone to select us out of the Queen's Park Oval to come here to sit down to dictate to others who have walked the ground and have gotten the votes of the people.
Mr. President, I rise to raise Section 42.9 or Rule 42.9, Standing Order 42.9.
Well, after you go clarify. He'll clarify after, no problem. Mr. President.
Yes. Please, stop, please. Stop the crosstalk, please. Yeah. At the end of his statement. At the end of his statement, continue.
Thank you, Mr. President. I mean, some of them who are Attorney General don't even know the standing orders. That's why he brought so much poor legislation that get overturned in the courts every minute. Let me just say, Mr. President, for example, in the last 10 years, and I'm going to talk for myself, if I walked once per week, 3 hours every Saturday, I would touch at least 120 to 150 citizens' hands and speak to them, listen to them. By 52 weeks, that's 7,800 citizens. By 10 years, that's 78,000 citizens, minus some if you repeat meeting somebody twice and so on. At spot meetings, Monday Night Forum, as the Douglas, the UNC senator, daily interactions by the double stand in the grocery, in the pharmacy. This is at least 3,650 people per year by 10 years. That's another 36,500 people. Functions, fetes, sporting events, 1 per month, 100 people per event times 12 by 10 years, 12,000 more people. A grand total of 126,500 people consulted with, listening to, hearing, and then formulating policy. Press conferences, social media presence, doubles and coffee, interviews, are than more thousands of people. So for senators who are selected and we never saw them before to come and attack the government and attack MPs and attack senators and attack politicians, you don't understand our job. I prefer you to come and say, how did you get here? I'm not sure how you got here, but I know how we got here. The people voted for us. And those numbers were just for me, Mr. President. For the Honorable Kamala Persad-Bissessar, the Prime Minister of Trinidad and Tobago, multiply that by 10. So she has consulted, she has demanded, and she wants to keep her promise to the people. And Senator Lewis, I make that argument to let you know. It's too much power in the hands of the Prime Minister. The Prime Minister has asked and earned the right to listen and to impact the people's lives. So for us to sit down, and you always start all of your contributions by saying, I haven't been here long, I have just arrived, I am just here. Kamala Persad-Bissessar has been there for 40 years, walking and talking and working. So please, give a little bit of respect. She didn't reach there by magic. Understand that, because it's very difficult to sit down and listen when you have not walked in the shoes of those who stand here. We could debate, but even now I could see that some of you all getting touchy. But when you all sit down and talk, I didn't jump up on those standing orders because I come to debate. I ain't afraid debate, and I certainly ain't afraid them in the front there. That's why them. The honorable member with a good name, Senator Melanie Roberts Rajman, said we criticized the PNM methodology in crime fighting. We did no such thing because the PNM had no methodology. Senator John Bates said that we suspend rights in the name of safety and security. Well, that one, I nearly fall off my chair and I was sitting down. I had to listen and read it over, because I thought I took my notes wrong. We suspend rights in the name of safety and security. So when else you should suspend rights? Life. You are alive. I'm looking at you. You are sitting there listening. That's life. Without life, we cannot debate. We cannot live. We cannot look at our children and be proud. This bill here is to protect life. That's all. Don't go into any other old talk, because once you're dead, and it wasn't your former Prime Minister say, who dead? Well, who dead can't debate? As a father, I would suspend, because you also said you brought up fatherhood and parents, and somebody senators. As a father, I am telling you that I would suspend all the rights of my children to ensure their safety. All. If I want to ensure my children safe, stay home, you ain't going nowhere. No vet, no shopping, even no sport. If it's a risk to your safety, I would do anything and everything to keep my children safe. There would even be no school. If my child was being bullied, I would not send my child to school. So I don't know what we're debating here. This is a bill to keep people safe, to save lives, to stop people from being bullied by criminal gangs that have taken over. You sit down and we lime and we go to cocktail parties, but you do not walk the streets. You do not understand. The people want this. The people want safety. The people want to live as if they're in Goodwood Park, as if they're in Newbury Hill, as if they're in Mary Avenue. They want a security guard. They want community comfort patrol. When the police drive wrong, don't you all feel safe when you see a police car in your neighborhood? You may be outside watering the plants. Don't you feel safe? Already? Hold on. Abuse of power arguments were made. And yes, anywhere power is given, there is the risk of abuse. We saw a possible recent example of that. And we will await the investigation into that. But for the PNM to pretend like only them are upset if police abuse their power, that is ridiculous. Anybody who abuses their power has to be reeled in, has to be monitored. That is a risk, and we must mitigate against it. But do not say that we must not keep people safe and keep them alive because there may be some bad police. Well, look in here. Let me shut down the Senate because it have some bad senators or the PNM there, so we just shut it down. They have a former PNM minister who used his power and influence for his family to benefit from over $500 million in contracts. Isn't that an abuse of power? Wherever people get power in over history, there are abuses of power. Another former PNM minister used his power to get rental for his building without the correct approvals. Isn't that abuse of power? Should we stop all rentals from everybody? Or should we just zone in on those who break the law? There's a teacher in 1969 who had power over the children and used that power to impregnate a girl of school age. What about that? Anywhere there are people who have power, we have to be vigilant. So yes, the police have been given power, but the police already have great power. In 2021, when we saw that video up in Laventille with the gold teeter, there was no state of emergency. There were no special powers, but the police appeared to do everything wrong, and they have to be dealt with, and I believe some were suspended, and that case might be still investigation pending. But of course, anytime to whom much is given, much is expected. So yes, we will have to monitor the police. That is the job of the Commissioner of Police, the PCA, the Ministry of Defense, and so on, of course. But you cannot say that all the police bad, because that's not true. One minute. Ooh. Well, they brought race into this thing. Well, you know, the Douglas don't mind talking race, because I'm a proud African from Tobago by my father, and a proud East Indian, very proud East Indian from my sari-wearing mother. And when I used to go to stores, but I come from a different place, because I never understood anything about race, because my whole life was just everybody live. And I used to go in stores, and all the clerks and the people helping would ask me, "Is that your mother?" Because she had 3 boys with little afro, and I had hair and thing. And I never understood what they were talking about. But it's only when interacting with the PNM and the superficial race baiting that I understand what the people were asking me. They could not believe, even though my face is exactly that of my mother's, they could not believe by the texture of my hair and the color of my skin that that was my mother in the sari. And we have to get away from that. We have to live like Douglas. We have to live free of race. This is not about race. This is about safety. This is about our children are dying, stopping the bloodshed. So we ask for your support. We don't beg for it. We don't go to hug up for it, but we ask for it.
Senator Michael De La Voisin.
Mr. President, the goodly senator suggested that I, in my contribution, stated that the government was disrespectful to us, the independent bench and the opposition senators, in not consulting with us before the bill. I certainly never said those words. I certainly never stated anything that would suggest that they were being disrespectful to us. What I suggested was that a better approach would be to consult with us before the bill and see whether in order to obtain our support, instead of throwing insults and that sort of thing. That's all, man.
Amery, Dr. Amery Browne. Senator Dr. Amery Browne.
Thank you very much, Mr. President. Mr. President, the context has been set. There have been many contributions in this debate, and I want to recognize from the onset of my presentation that there's considerable national interest in this discourse taking place in the Parliament of Trinidad and Tobago. the attention of the public and those outside of the precincts of the Parliament, I would believe is quite rightfully focused on this debate because the stakes are very high, and in my humble opinion, certainly since the beginning of this session of Parliament, the stakes have never been higher. The government has come to us today and last week and before in what is now an extended debate, asking for something extraordinary. They've come with an extraordinary proposal. And Mr. President, I've been around for a little while, and I've participated in a number of special majority debates. And I have to confess to you my surprise at the tone, the nature, the content, the attitude, and interface coming from the government bench in this particular debate. The context and the backdrop set by none other than the Prime Minister herself. I do not need to regale the Senate of the words of the Prime Minister because they've been shared by some of those preceding me. But to see contributors on the government bench in the Senate, senators, not just reinforcing, but doubling down on that attitude is stunning, Mr. President, when this government is expecting the votes of senators in a special majority vote. Mr. President, I listened painfully to Senator Roberts a short while ago, and it appeared, just as before, to be a case of selectees attacking selectees because they are selected.
Mr. President.
Mr.
Yes.
Mr. President, I rise on Standing Order 46-1. His contribution so far is totally irrelevant to what is before us. Totally irrelevant.
Yeah, I'm giving him the opportunity and sound to develop his point. Continue.
Thank you, Mr. President. My goodness. Appears the member was asleep during the preceding contribution. Mr. President, I thank you for setting the environment for free speech in the Parliament. I will continue. Mr. President, so a selectee is standing up here shouting and berating other senators simply on the basis that they are also selectees. Mr. President, that belies and betrays a fundamental misunderstanding on the part of Senator Roberts and the Prime Minister of this country, a fundamental misunderstanding of the Constitution of the Republic of Trinidad and Tobago. And if it is the expectation that Senator Alwari, Senator Cummings, Senator De La Bastide, Senator Lewis, or any other senator would just turn up here to rubber stamp or automatically agree or endorse any measure brought by the executive, tells me that this is a government completely out of control. The very purpose of this Parliament is to provide oversight over the executive, Mr. President. What could be more fundamental than that? And then they accuse us of lecturing. I heard, and I was a little flattered, an independent senator is now also being accused of lecturing. Apparently that is the label ascribed to some of we are lecturing. Mr. President, if a contribution might be delivered in respectful and rational tones, and if the content
Mr.
does
President,
not
46-1, he's going on too long on that. Let him get on with the debate.
Yeah. Continue, please.
Thank you, Mr. President. Mr. President, if a contribution is lacking in insults and invective and personal attack, if that is what makes levels an accusation of being a lecture, I'm guilty as charged, because you will get none of that from the bench of the People's National Movement, Mr. President. None of it. And then the senator who preceded me gave a long, meandering attack on the basis of corruption and on the basis of misuse of state resources. And I sat here waiting patiently for some application of his 40 minutes to give this nation some insights into the architecture and the workings of the live sport program, which fell under the Ministry of Sport in times past. We got not a single word or wink from him in that particular regard, Mr. President. And I thought that was worth noting in this particular debate. Mr. President, no matter how they twist it, they are asking us to replace a state of emergency, which is currently ongoing, which still exists in Trinidad and Tobago, to replace that, which they claim is not related to the crime situation, with their new formulation, which is a zones of special operation, which curtails the constitutional rights of some citizens of Trinidad and Tobago based on geography. Citizens of their choosing based on geography. And Mr. President, in my respectful view, this bill collapses from the very first reference. Because I see some of my colleagues maybe yielding to the temptation, and I want to say it very clearly, of saying, well, listen, there's a bill before us, and let's work together to try to make it the best possible law. So let's amend, let's tweak, etc. But when, Mr. President, the first test, before we even get there, is has the government made a cogent case for the need for these measures in the first place? And that case has not been made. And that's why they've been shouting and bullying and badgering and insulting and berating. They have failed to make that simple prima facie case. Mr. President, I want to start right at clause 6.1 in part 2.
Mr. President, I rise on standing order 46.6, imputing improper motive against any member, offensive reference to members. The member there is speaking about the conduct of us on this side, about bullying and badgering, when that is not something that we have been doing. That's offensive.
I want to sustain that point. Point of order, please. Do not. No. Take a seat. I'm sustaining that point of order, and I am asking you, don't go down that road. Continue, please.
Thank you, Mr. President. Mr. President, I had already moved on to clause 6.1 of this bill, part 2, zone of special operations. And the entire case of this government collapses right here. Where there are reasonable grounds to believe. Mr. President, that should be cause for pause for anyone in this country. Everything hinges around this phrasing. Everything else in the bill flows from here. Where there are reasonable grounds to believe. And believe by who? The Prime Minister. The Prime Minister of Trinidad and Tobago. This is the first time I've participated in a debate that even approaches the reality of giving the Prime Minister of this republic such extraordinary powers. Indeed, Mr. President.
This is the standing order 53(1)B. This is tedious repetition now. We've been going through this Prime Minister talk for the last...
Okay. Yeah. I think this is the problem that we are entering into a phase of tedious repetition. 6.1 has been repeatedly articulated, and you are just repeating arguments that have already gone. And that's the problem when we come too late in this debate. So I sustain the point made by the Honorable Senator, and I ask you to move on from 6.1. We have heard 6.1 for the last 4 days, right? Go on to some other point. I'm warning people, whoever is speaking after, do not engage in tedious repetition. I'll warn you once, and I'll warn you twice. After that, you resume your seat. Okay? No tedious repetition. Continue, please.
Mr. President, I use the phrase, and I know the government is very uncomfortable, I use the phrase, the case has collapsed, because this government has exerted considerable energy in trying to convince this population that crime is down in Trinidad and Tobago. Crime is down, murders are down in Trinidad and Tobago. I saw an article dated December 16, 2025 in the Trinidad Guardian claiming that homicides are down by 66% in the urban Port of Spain division. That is the case this government has been making consistently during the state of the emergency. But somehow, by magic, by osmosis, they expect this Senate to believe that there's some alarming, unusual, emergency reality that would justify the granting of these emergency powers to the Prime Minister. Mr. President, the case has not been made. That's why I use the phrase, and I respectfully to the senator who intervened, it's not a repetition. I'm giving my own perspective as a senator on this particular debate. But I am guided. Mr. President, no matter how they twist it, this bill will affect a range of constitutional rights that all of our citizens are entitled to. The constitutional right to free movement, enjoyment of property, protection from arrest and arbitrary search, and due process. The point is this, Mr. President, in a democracy, the presumption of your innocence should never, ever depend on where you live. Let me repeat that, Mr. President. In a democracy, the presumption of your innocence and the protection of the Constitution should never, ever depend on where you live. So this is a very right-wing and unusual approach. Mr. President, I want to tell you, and it has not been raised in this debate at all, I want to tell this Senate and those who are paying attention that this is not the first time. This is not the first time this government, this UNC, has attempted this type of measure. Mr. President, I draw to your attention the reality that took place in the year 2011 and I refer to a newspaper article, the Trinidad Guardian by Reshma Raghunath, on the 21st of August 2011. The headline is instructive. Prime Minister declares limited state of emergency. What was that about? There was a lot of attention around that phrase, limited state of emergency. And this is the contents of the article, Mr. President. Last night, Prasad Bisesa, referring to the Honorable Prime Minister at the time, after an emergency meeting with members of the National Security and her cabinet at her private Philippine San Fernando residence, interesting location for the meeting, said, the limited state of emergency will take place from midnight tonight, that night. A tough-talking Prasad Bisesa, backed by the Chief of Defense Staff, etc., said, this is not an easy decision to make. It is not a light thing to trigger Section 8(1) of our Constitution, but when the circumstances call for it, I believe it's the right thing to do. The article went on. I won't read the entire thing, Mr. President. While she, and I'm quoting, while she shied away from revealing the areas identified as hotspots, the Trinidad Guardian understands that 11 communities have been named in the limited state of emergency. And then the article outlines what the president himself signed at the time. What did she then do, Mr. President? there was the arrest of over 8,000 individuals.
Mr. President, I rise on standing order. Mr. President.
Listen, I notice a tendency developing. When a member rises on a point of order, the member who is speaking immediately takes a seat. You can't have the member speaking, standing, and the member who is raising the point of order standing. That is going to create disorder in the chamber. So may I advise, kindly advise, that when a member rises on a point of order, the member who is speaking, resume your seat and let the member proceed with this point of order. Senator, I recognize you.
Thank you most kindly, Mr. President. Mr. President, and rise on standing order 46.5. The honourable member, while reading the article, continued to refer to the Honourable Prime Minister by her name and by referring to her as she. Would like the honourable member, when he's delivering and he takes ownership of the article and he addressed the Honourable Prime Minister by the right title, that is to be used in the debate. Thank you.
I'm sure you are going to be guided by that, so just refer to the Prime Minister by her proper title.
Mr. President, I also rise on 46.4 and or 46.6. I don't know if the member was quoting or what he was quoting from. If it's the Guardian, it does make a difference. But he said something about the Prime Minister arresting somebody. The Prime Minister never doesn't arrest people.
You want to clarify that point?
Thank you, Mr. President. I never said what Prime Minister has a power of arrest. Mr. President, I'm going to move on because I know what they are about completely in this matter, Mr. President. Mr. President, 2 days later, the Law Association had cause to intervene in this matter. The Law Association, and you see the attacks continue. It's very unpersuasive. The Trinidad Express, on August 23rd, this was August 21st, now in August 23rd, 2011, the title of this article, the caption is, Law Association, there's no such thing as limited state of emergency. And to summarize, I will quote, the Council of the Law Association says it expects the government will apprise citizens of this country before the state of emergency expires of the impact of the measures. And this is Mr. President, if Senator, what's his name? Philip Alexander. Mr. President, this senator, if I could respond to his contribution, stood here and gave us an attempt to sanctify his resume. He's an activist, he's an activist, he's an activist. Now he's coming here to disturb me.
Mr. President, 46.4, insulting, offensive.
May I appeal? Because, I have the power, which I do not use. I pride myself as being a Democrat. So I ask members, let us reduce the crosstalk. A member is speaking, allow him to speak. If there's a point of order, you rise, I'll recognize, and rule. But we cannot have this excessive, continuous cross-talking. It disturbs the proceedings, and it shows disrespect to this chamber. So I'm appealing to members to allow the member to speak, and if you have any problems, rise on a point of order. Continue, please.
Thank you very much, Mr. President. Mr. President,
I rise on 46.4. By both of them, and while you were speaking, Senator Al-Rawi was saying the most disgusting things about me. And that is not the first time they've done it, both of them. I was not given the opportunity that I gave Senator Boodhu.
Okay. Okay, just have a seat. I didn't hear. I must admit to you, Senator Alexander, I did not hear any remarks being made by Senator Al-Wari towards you. If you wish, you can put it in writing, and we'll do an audio check to see if it confirms what you have said. Well, I didn't hear, and I don't want anyone to repeat what he would have said that I didn't hear. So at this time, continue, please.
Thank you very much, Mr. President. Mr. President, if I could be allowed to complete my point in respect of my freedom of speech in this Senate, it is this. The Council, in a statement yesterday signed by its president, Senior Counsel Dana Sitahal, is calling on the government to state what is its intention regarding any extension of the state of emergency. Mrs. Sitahal said, the entire country of Trinidad and Tobago is under a state of emergency. There is no limited state of emergency. There is no limited state of emergency. The Council wishes it to be noted that this state of emergency is not in the least limited in fact or impact. Why am I saying this, Mr. President? This is not the first time. No matter what new or novel or unusual circumstances the government is attempting to paint in this country in the year 2026, this is not the first time they've attempted to discriminate and impose state of emergency conditions outside of the constitutional arrangements for same, and to impose them based on geographic determinations. Determined by exactly, Mr. President, he's taking me where I want to go. So whether we are talking about this administration, the next administration, a former administration, that power, the leader of government business shouted out, remember when they put a SOE for the speaker?
Mr. President, he's pointing at me. That's very rude.
Don't point. He doesn't want to point. Continue.
I wouldn't point at him. But I may gesture in making my point to the government bench. Thank you very much. Mr. President, this is not the first time they've attempted this. And the power that they are seeking, the weak case that they've made, does not justify this government, the next government, or any government being granted this unusual powers. So I've been prevented from going into clause 6, so I will not belabor that point. Mr. President, I have some considerations that I would like to share at this stage of the debate to basically tie the opposition's case and concerns together. And I will pose them in the way of questions to the government of Trinidad and Tobago and questions to all senators who would be considering the matter at hand. First of all, has the government's case been based on evidence? Has data been presented, Mr. Attorney General, through you, Mr. President, in this debate to support the measures being advanced by this government at this time? I would say not, Mr. President. What I did hear is considerable fear-based presentations. I heard the young senator who speaks very well, Senator Daniel Rashid, make an entire presentation on two alleged cases. Maria and what was Jack and Maria. An entire 40 minutes, all hinged around one word, fear. But Mr. President, fear is no substitute for evidence, data, and persuasion. So we have to make our decisions based on evidence. So I would have wanted the government to respect this debate sufficiently to present a better case than that.
I stand on 53(1)B. This point has been raised. The ask for evidence has been made by Senator Atts and was answered.
What's this?
53(1)B, this is a repetitive point.
Can we just have a seat? Members, I'm on my legs. Can I have silence? Could you quote the standing order that you're
I
referring
stood
to?
on 53(1)B. His ask is for data to be presented. This ask has already been made by Senator Atts and answered.
I think Senator Browne doesn't have much more time at his disposal. I'll allow him to continue. You finished?
Just after 4. Thank you, Mr. President. Thank you, Mr. President. I appreciate it. Mr. President, secondly, given the nature of the request of us as senators, can this government be trusted? Have they demonstrated sufficient transparency to justify the granting of these extraordinary powers? I dare say, Mr. President, they have not. Even in the nature of these exchanges, there's a demonstration of unwillingness to be examined, unwillingness to even receive or respond to questions. And under those circumstances, how can we entrust them in these circumstances? Mr. President, I started by saying this is a very bizarre debate. Very, very bizarre. And then you had the Minister of Defense talking about it's a good start if somebody's pants is hanging down, maybe they have a gun. Very, very, does not for trust make, Mr. President. Mr. President, I also want to indicate that it is expected of all governments of Trinidad and Tobago that they demonstrate adherence, not just to domestic law, but international law as well. Mr. President, I have a question. Should the circumstances around the implementation of this bill not go as the population would wish or as the government would wish, should we end up in a militarized condition similar? We are all familiar with what's happening in the United States of America. It's relevant to our circumstance as the potential when less than well-trained individuals.
Mr. President, 46-1.
Have a seat.
46-1.
Have a seat.
How is that remotely relevant, Mr. President, to the bill? Talking about the U.S. and foreign affairs. 46-1, Mr. President. Relevance.
Yeah, just connect your points so at least, the relevance could be shown, please.
Mr. President, what we are contemplating here is to send in police and the defense force by geographic determination into community. What could be more relevant than that? It's happening every day on our headlines,
Mr. President, 53(1)B, that is persistent, tedious, and repetitious.
I will determine tedious repetition. Continue.
Thank you very much, Mr. President. They're afraid of the truth. They can't handle the truth.
Mr. President, why is he shouting?
So, Mr. President, the lecture will resume. The lecture will resume. So, Mr. President,
Mr. President, standing order.
Sit down.
Mr. President, standing order.
Sit down.
Standing order on a point of order, Mr. President.
No. Take a seat. Take a seat. Take your seat. Now listen. We cannot continue to defy rules in this House. This is a rules-based order. You are rising on a point of order. Could you identify the point of order, please?
Mr. President, I stood on Standing Order 46.4 and 46.6, the last outburst by the member that was speaking.
Okay, members, I know the temperature is rising, so although we are coming to the end of your contribution, temperature is rising. Let's conduct ourselves in a dignified and civilized manner, and not engage in any kind of responses that could warrant continuous intervention. Read the standing orders. Continue, please.
Mr. President, I say it again. This government cannot handle the truth, and they cannot stand scrutiny. They do not receive questions. They do not respond to questions, and therefore their case has collapsed.
Mr. President, I stand on 46.1. Mr. President, I stand on 46.1. This has no relevance to the debate that we're doing right now.
And for injury time.
Well, you have no injury time to get. Like the first one. I'm going to allow you to continue, Senator Browne, but please connect your points to some aspect of the legislation as far as is practically possible. Please continue.
Thank you, Mr. President. Mr. President, okay. Let's go on to question number 3. Is there a limit to the number or range of these zones? What prevents this government or any government from declaring a special zone across all of Trinidad and Tobago, with the exception of one village or one island, let's say Tobago, or any other location? And that completely circumvents the intention to avoid a declaration of a state of emergency. In other words, are we giving the government a tool of convenience which allows them to circumvent this constitution as it exists, but to achieve the same purport of a state of emergency? Mr. President, that is a...
53.1b, where mention was made already by that bench of a mini SOE and addressed.
Both of you can't stand at the same time. I think he's moving on. Continue.
Mr. President, on the issue of funding, we got a lot of verbiage on social programs. In fact, the member who just tried to intervene gave some verbiage on social programs. But, Mr. President, what happens to these individuals in those communities declared as a special zone?
Mr. President,
the government...
I just came back in tedious repetition.
I think that point has been made, Senator Browne, as you know. So if you could move on to some other point, or if you're developing a new point under the Social Transformation Committee, I think it would be acceptable.
Thank you, Mr. President. Mr. President, the government has said that they respect democracy. I heard presentations by the democratically elected representatives of the people of urban areas in Trinidad and Tobago in this parliament indicate that the people that they represent do not want the imposition of these special zones. I heard that with my own 2 ears. And then you have unelected, by their own admission, senators standing up to say they know what the people want. If we respect democracy, why are we subjugating the voices of the duly elected people of these constituencies, Mr. President? Why is that so? Why is that so? And then they want to pin them in at the end on a committee when it's already a fait accompli. Mr. President, the government has to respond to these considerations. They spoke in the lower house of debate, and the government has not presented any support for this claim that the people of Sealots, the people of Beetham, the people of Covine and Factory Road want the imposition of these special zones. The least they could have done is engage in some formal mechanism of consultation. There was enough time, maybe not in the...
Mr. President, I stand on 53.
Sit down.
Sit down.
Just a second. Senator Rashid, could you apologize?
I apologize.
Listen, only one person in this house can order somebody to take their seat. Nobody else. That is disrespectful. It will not be tolerated in this house. Okay? There's only one presiding officer in this house. So I don't want anyone to take it upon themselves to tell any member of this Senate, whether it's government, independent, or opposition, sit down. That is totally out of line and will not be tolerated in this house. I make myself clear. You have a point of order? Raise your point of order.
Mr. President, I stand on Standing Order 53-1B. The consultation thing has been spoken about by every PNM member.
Yes. Senator Browne, you have 3 more minutes and so on. Use it properly.
Thank you, Mr. President. Mr. President, and again, I think there's a misunderstanding. Just throwing a phrase does not mean there's repetition. I'm giving my own personal perspective as a senator on the issue. And what I'm saying is the duly elected representatives of these persons have said the people don't want this imposition, Mr. President. Mr. President, I will move...
Rise on Standing Order 53-1B. He is now repeating, even himself is repeating what he himself had said, and he continues to repeat.
Yeah. Senator Browne, unless you have something new that you'd like to put on the table, I think you just have 2 more minutes. I ask you to use those 2 minutes productively, please.
Thank you, Mr. President. Mr. President, I once served as the Minister of Foreign and CARICOM Affairs of this country. And I have done an examination of other societies in which some citizens, depending on geography, have different rights than other citizens. And some of the examples I was able to find include the land of Gaza, where some citizens have more rights than others, depending on geography. I was able to find...
Mr. President, 46-4, and you should nip this before it goes down that road.
Listen. What's your point of order, Senator?
This road...
No, what is your...
46-4.
46-4. What is the imputation?
Mr. President, he is about to compare Trinidad and Tobago to war-torn regions and use their...
No. All right, okay. No. I don't... If he's going there and it is egregious, I will intervene. Continue, please.
Mr. President, I see what they're about. They will not succeed in this debate. Mr. President, I want to close by quoting the words of the Prime Minister of Canada, the Honorable Mark Carney, who gave a historic speech this week in Switzerland. And he said this: "The power of the powerless begins with honesty. The power of the powerless begins with honesty." If we cannot have a rational debate on an issue of this magnitude, unprecedented in parliamentary history,
Member. Yeah. 49, you have to take a seat. Yeah. Take a seat. All right, thank you very much. Shouting doesn't mean that it will happen. So we don't have to sit there. Okay. I now call on the Honorable Attorney General.
Mr. President, it has been a long debate lasting 4 days so far, and the tempers have become understandably frayed in that time. I should just like to begin by, I have not been here as well, Mr. President, so that I was able to follow some of the debate from distance. Now, as I understand it, and I have to ask the forgiveness of the Senate for disregarding in large part the contributions of Senator Boodhu, Senator John Bates, Senator Cummings, Senator Roberts Rajman, and my good friend, Senator Browne, who I don't mean to insult them, but I don't think that they added much to the substance of the debate. Now, I left Senator Amery, of course, for last, because I'll begin with him. But before I get there, I just want to sketch the issues which reared their heads over the past 4 days. There was some discussion about a sunset clause. There was some discussion about clarifying and limiting the Prime Minister's powers. There was some discussion about possibly shorter time frames for zones. Also, extraordinary powers were said to be justifiable only by clear, transparent, and defensible criteria exercised with strong safeguards, oversight, and accountability, and implemented in a way that avoids stigmatizing entire communities. There was as well some commentary on the declaration of a zone, what is meant by threats to the rule of law, rampant criminality, etc. There was some suggestion with respect to enhanced reporting, strengthening parliamentary oversight, body-worn cameras, and the Social Transformation Committee. Now, I returned to all of them in the course of what I propose to say shortly. If I could just, by way of introduction as well, say that in the course of the past 4 days, we have had a bill with 28 clauses, a bill that was drafted by my friends opposite, modeled on the Jamaican zones legislation in 2017, authored by Senator Amery, still visible on the website of the Trinidad and Tobago Law Association, all of the correspondence from the Prime Minister to the Law Association, from the Prime Minister to this one, and so on and so forth. The impression that has been created is that, one, the Honorable Prime Minister is a dictator, that this legislation is new in some way, that, and I have to say that this, before anyone jumps up on a point of order, this has to be the height of dishonesty. For you to draft a bill, for you to claim the bill, for you to sell the bill, and then for you to come to this House and pretend that you know nothing of the legislation. The legislation is legislation of the big bad UNC and the big bad Honorable Prime Minister. That is the height of dishonesty. Now, in those 28 clauses, I have counted 50, close to 50, it may be 48, close to 50 proposed amendments. And I propose to outline the government's position on this matter at the end of my winding up. And those 50 came by way of 22 separate proposals. Some amendments then amended themselves. And it is mind-boggling. And in the Office of the Attorney General, we have staff who have been in place for quite some time. So the author of the legislation in 2017 happens to be the author of the legislation today. And he is not too far away in Cabildo House, looking at the proceedings and in a state of bewilderment as to what is going on. Nevertheless, Mr. President, I will attempt to do the best that I can by him, by the public servants who have worked on this measure, and by the people of the Republic of Trinidad and Tobago. Now, I believe it was Senator McNeish who noted that no other strategy has yielded significant nor comparable results in suppressing gang-related homicide and serious crime rates as the state of emergency. He went on to say, however, that continuous states of emergency over an indefinite period of time, while they may effectively suppress crime, cannot be a tenable solution. We on this side are fully cognizant of that, as my colleagues on the other side, when they wore different hats, were. Now, the fact is that this state of emergency, which ends in 4 days' time, was not called, was not declared to deal with gang activity. And that is different from what my friends on the other side did. In December, and they like to speak of what happens on Christmas Eve and who is the Grinch of Christmas and so on and so forth. On December the 30th, 2024, the nation awoke to the declaration of a state of emergency. Not by the Prime Minister, who was sipping a glass. There's a camera everywhere now. He was sipping a glass in Tobago. That is fact. Not by him. I don't know what was in the glass. I would not get to that. He was partying in Tobago. The state of emergency was declared by the younger one. That's all I will say. And it was declared for the express purpose of dealing with what? Gang-related reprisal crime. That is it. Gang-related reprisal crime. That went on until a week or two before the general election, believe it or not. That state of emergency, it was renewed 14 days after. It went on until 2 weeks or so before a general election. an act of greater suicide, I do not know. They went into a general election in a state of emergency and have the temerity to come this afternoon to tell us about what is democratic and what is not democratic. Mr. President, gang-related homicide is a serious thing in this country. As a matter of fact, the former leader of my colleagues declared it a national health emergency. Public health, I stand corrected. Now, in July of 2025, heads of government, and my friend Senator Browne would know of this, were sufficiently alarmed at this to say that, and I quote, "The scourge of gun crime and violence across the Caribbean region, driven by the proliferation of illegal firearms and the activities of what? Gangs and other organized criminal groups, continue to pose a serious threat to the region." Now, heads are talking there primarily about three countries. Haiti, in which the gangs have overwhelmed the government. Jamaica, in which our colleagues have taken appropriate steps to prevent exactly that, and Trinidad and Tobago. And they went on. They said, gang-related crime continues to pose a serious threat to the region. Its institutions of governance, that's not my words, its institutions of governance and the very fabric of our societies. Now, that was in July of 2025 in Montego Bay. Now, I want us to pause for a second, because what heads were saying was that they were aware of the developments in Haiti, aware of the developments in Jamaica, aware of the developments in Trinidad and Tobago, and that they viewed those developments as existential threats to governance, gangs ruling society. Jamaica and Trinidad and Tobago permitted themselves to express deep concern. That is in the wording of the communique. And, Mr. President, you have been around long enough to know that that is diplomatic speak for panic. In my piloting of the bill, I read from a report of the Trinidad and Tobago Police Service, and I heard my friend Senator Browne saying that, well, there's no data. I read from reports of the TTPS. And those reports clearly identified that gang-related, serious gang-related crime, murders in particular, demonstrate, I don't know how more data-driven you could get than this, historical geographic concentrations in Trinidad and Tobago. They went on to say, this is the TTPS, not the PNM party group, not the UNC, the TTPS. They said national statistics are heavily skewed by criminal activity in these areas. And they went on to say that nationwide interventions, like the state of emergency, do not often take that fact into account. Well, Mr. President, I want to tell you something this afternoon. We are here to treat with a specific problem, one that was recognized by them, one that is recognized by the heads of government in the region, one that is recognized by us. No, I am not giving me. And unless you have a point of order, all right. So, Mr. President, this is a serious problem. It is the problem has been outlined to us at the national level by our police service, by our intelligence agencies, by heads of government who have at their disposal in CARICOM impacts a regional intelligence body. Now, we say on this side that efforts and resources must be proportionately allocated to the areas in which there is literal warfare being waged by rival gangs. I spoke of situations where you have a half of a street belonging to one gang in my piloting of the bill, another half belonging to someone else. And if you are unfortunate enough to stray across to one side of the street, that's it for you. Now, gang-related crime has affected law-abiding citizens in the communities that my friends speak of. Exactly. I know because I was born in Bella Road, which is supposed to be the headquarters of 6. Okay? I was born in Bella Road. I grew up in Bella Road in Belmont. Now, there have been, and when I say I grew up in Bella Road in Belmont, I had, without going into details, and this is not, as a man, I don't wish to speak about it. As a child, I had someone who would help me, a babysitter. And that woman found herself in my office as Attorney General to ask me if I could do something. I couldn't. About sending army into her area where she lives in Belmont because she says she cannot sleep at night. This is a woman who took care of me as a child. She's an elderly person. There are good and decent persons in these communities who live under panic every night. What we propose in this bill is an approach that stamps out the gangs institutionally, eliminates the socio-economic dysfunction that has enabled their existence. The measures are outlined in the bill. I outlined them in piloting the bill. They've been spoken to at length over the past 4 days. While I was in Barbados, as I went to the Attorney General's round table, and we spoke on crime and also on gang-related crime. I interfaced with my colleagues from Jamaica up to this morning, and they say that the impact of this legislation, the ZOSOs, has been significant. They say so. But they also say that it has to be carefully calibrated well thought out, meticulously deployed, finely balanced, and well resourced, because that community engagement bit of it has to be well resourced. You are talking about once you establish a police, and I've heard my friends talking about the army and the army being trained to fight wars. There have been no wars in Trinidad ever. In 1970 and 1990, the army was called upon to put down an insurrection. So what that means is that, taking 1990, for 35 years, the army has functioned as a constabulary force. All that they do is to support the Trinidad and Tobago Police Service. And it is not nonsense, it is arrant nonsense to say that all of a sudden, these persons who are trained to do what armies are trained to do, but who have been for generations. So you have people who have joined the army, left the army, their kids have come in, left the army, who have only had experience with the army as a constabulary force. There's an acronym for JAPS, Joint Army Police Patrols. That's it. But my friends opposite are hell-bent on opposing for the sake of opposition. The idea that the army should help the police. Well, it is a force multiplier, and they are needed to assist the police. This is not a new problem. We've had JAPs, Joint Army Police Patrols, for decades, as I've said. Now, if I could just go back, and this is because of the criticism that I did not speak to statistical data. In the, I don't like to quote that gentleman who, if somebody, let me take myself out of it. I don't like to quote a particular prime minister. I don't think he's deserving, worthy of being quoted in this house. But I'll make this exception just this time. He said of this law, the draft law has the potential, these are his words, Now, he speaks out of, so he'll say, you're a dog today. I received that. I wear it as a badge of honor. It didn't matter to me. And then some other time he'll say something else when it suits him. But he said these words, the draft law has the potential to deepen and to sustain on the ground anti-crime activities of the protective services in areas of high criminality. Now, that's the same bill, basically, that we're dealing with here today. But he lacked the courage, as he always does. He failed to follow through on it. And if he did not lack the courage, he lacked the incentive, because he liked to play golf. He used to be found on the 9th hole of wherever in Tobago. In a report by the TTPS, Trinidad and Tobago Gang Review 2016-2017, the Criminal Gang and Intelligence Unit of the TTPS, which he referred to, said these words. During the period 1st January 2016 to June 2017, the number of gangs and its members existing in Trinidad and Tobago has grown exponentially. He said that almost 10 years ago. What did he do? Nothing. Now, he had the data, he had the law, he had the resources, he was in power, and one place that he was not, he may have been elsewhere, as I say, the ninth hole, he was not here, and he was not piloting this bill. That's what he was not doing. Mr. President, I said last week that this government would never allow the country to slide back into the state of anarchy in which we found it in 9 months ago. We will not, I said, allow the hypocrisy of those on the other side to distract us. Now, if I could just move quickly to speak to the contributions of the members. Okay. Senator Arawi. Well, Senator Arawi was an Attorney General. I have looked at the legislation that he had before him, consulted the technocrat who is here, who drafted the bill, and I cannot for the life of me understand why, I take it that you learned something in your constitutional law classes. And if you did,
he was there long enough.
If you did, you would know that there's a difference between a constitutional amendment, which is governed by Section 54 of the Constitution, and a bill that is one that does not amend the Constitution, but might conflict with the entrenched rights. One has usually would have a 2/3 majority, the other would normally have a 3/5 majority. The Constitution tells you which is what. The constitutional clause for drafting what I would call a Section 54 bill, a constitutional amendment, would read something like this. This act shall be read as altering the Constitution. Why? Because it's an act that alters/amends the Constitution. But the constitutional clause for a Section 13 bill, one that does not amend the Constitution, but might conflict with a protected right, would read something like this. This act shall have effect, even though inconsistent with 4 and 5, that's the entrenched rights of the Constitution. Now, if you look at the bill before us, the preamble, Section 13 may expressly declare, shall have effect even though so and so, whereas it is expedient to do so and so. This act shall have effect even though inconsistent with Sections 4 and 5. It is not an amendment to the Constitution. And I would be happy to have a refresher course for Senator Arawi at the University of the West Indies on this at any time. So what I have to say on that, Senator Arawi, is that we on this side will not follow you down the rabbit hole that you have borrowed, squirrel yourself away in. The bill is the Section 13 preamble and constitutional clause is properly before us, and properly in the bill. I reject it. There will be no amendment. Now, on the other questions, now that we've dealt with the easy bit first, there was some discussion about a bare majority, and again?
And 454.
I think that should be enough. I hope I'm not good. That's the spirit. So there was some discussion about bare majority. And I just want us to go back to the Jamaican bill, which they unabashedly said, we copy it. That's what they said. Right. We copied it.
But nobody does listen to
Well, you know what? The Jamaican bill, a sealed copy, which was provided to me by my technocrat, shows that there was no constitutional preamble, no parliamentary certificate. What does that indicate? The bill was passed with no special majority. No special majority was thought to be required. Now, having said all of that, I hasten to add that their constitutional provisions are slightly different from ours. They have a referendum and so on and so forth. But the point is that it's a simple majority bill, especially since Surat and Suraj. Mr. President, if this government was anything but a decent government, and bearing in mind all that has happened here today, and the fact that constitutional majority is by no means assured, do you know what could be done and has been done in the past by some of my friends on the other side? I can amend this bill right now, take out the constitutional clause, and pass this bill with a simple majority. I will not do that. That's not how. That is not how we do business on this. Now, I just want to deal with Surat and Suraj and the points that make the legislative safeguards in the bill proportionate. One, there's a limitation on the duration with respect to which you can label a place as zone. Two, there is parliamentary oversight for an extension of a zone. Three, there's judicial oversight. You grab someone, it's not like a state of emergency where the writ of habeas corpus does not run in a state of emergency. You get someone in a state of emergency, what do? The Minister of National Homeland Security writes on a piece of paper, you are detained. That's a PDO. That's what it's called. And you know what? That person is detained. And his recourse is a tribunal established by the Chief Justice. This bill provides for judicial oversight. You have a magistrate, you have a judge. Then there's a time period on the duration for which you can hold someone in custody. The rights of prisoners are respected. Rights of counsel, family visits. I'm told, although I have not seen this myself, that you have a right to a person of your faith. The grounds of arrest must be in accordance with the prevailing law. The joint command provision, which requires that The Joint Command shall submit a written report to the NSC every 30 days. Parliamentary approval, parliamentary accountability, parliamentary review every 3 years. None of these is available in a state of emergency. All of these are indicators of the fact that the bill is proportional and that it meets the very real crisis outlined by heads of government, by the former Prime Minister, by the former Attorney General, and by us on this side. Now, the question is, what happens after an arrest in a zone? Well, the bill does not seek to deprive a suspect of his rights. As I've said, he's entitled to the normal rights that persons have under the Constitution, statute, and the common law, and the writ of habeas corpus obviously runs. I'm not going to speak to Senator Drayton's comments, although they were supportive in the main of the legislation. Now, I turn to the questions that I highlighted at the beginning when I said that these are the matters that I'll try to focus on. Why no sunset clause? We say the bill does not require a sunset clause because Clause 28 already provides for a review by way of a parliamentary committee. Further, the bill is not a short-term measure to address criminality and escalating levels of violence in the society. There's a lot of confusion that this is a bill that is, as my friends have done a remarkable job of selling to the people of Trinidad and Tobago, that this is legislation that will put an end to life as we know it. When we know, they quoted from a statement made by the Honorable Prime Minister in 2011, where she, the Honorable Prime Minister, saw the need to have special measures for special areas. In 2017, it was their Prime Minister. Now it is us. This is something that is required, and we have the courage to bring it to the Now, there's another reason why there's no sunset clause on it, and this has to do with the soft part of the legislation, the Social Transformation Committee. Once that starts, I'm told by my colleagues in Jamaica that that is actually a very powerful tool in terms of getting the communities to buy in to the fact that life can be better without the gangs. They are able to access services, they are able to come out of their houses, they are able to do things that they would not normally do when crossing the street is hazardous to their health and possibly might mean the end of their life. If you give people in these communities job opportunities, if you give them, if their problems are related to land tenure, their problems sometimes are related to health and so on. You want to have institutions which are inside of these communities which live. So this is really, as the long title to the bill suggests, something that is designed to to deal with the gang issue at its roots. Now, I'm going to ignore Senator Obika, Senator John Baines, and so on. there are some suggestions by Senator De La Bastille was concerned on consultation before the bill becomes law. Unfortunately, we cannot, given the nature of the threat that we now face, treat with any, it would be akin with respect to us looking on while Rome is burning. We know that this legislation works. We have the example of our partners as they did. What we can do and what I can commit to doing is to engage in a process afterwards to look at how as we did with AJIPA, this is not something that is new. When you pass legislation like that, urgent legislation, you look to see, okay, is it working here? Are there deficiencies here? How can we fix this? How can we improve this? But we cannot at this time delay this because we are committed to treating with the gang problem, which this has, we have now seen huge benefits from the state of emergency with respect to gangs. We are taking the opportunity now to press home that advantage. And Mr. President, I want to tell everyone in this Senate this afternoon, we are not going back. I just want to use 3 more words. No matter what. Now, Senator Vera, I trust that you would allow me to move on over your contribution, which I thought was interesting and progressive, on the use of the military. I think I've dealt with that. Senator McNeish, Senator Atz, well, the training of security forces deployed in the zone, that is something which we also consider to be a long-term measure. And Senator Lewis, the issue of executive overreach, we don't agree on that point. It is, as I say, it seems to us, and perhaps I'm not sure if I am being overly defensive, but this is the legislation which passed in Jamaica, which our friends opposite mooted. We do not see that there is a difficulty with having the Prime Minister in council, which is actually the way a state of emergency is declared. My friend would know. The National Security Council is the one that does the deed. The president simply signs on the dotted line. Now, I'm going to ignore completely this gentleman, Senator Obika.
Please ignore him.
And I am going to just deal with one point made by Senator Jones on rampant crime. I think that's, I accept that it's not something that you see in legislation every day. But it is an English word, it has an English meaning, and we think that it is appropriate and not ambiguous. Mr. President, with those words, I beg to move. I have to say, though, and that we have carefully considered the proposals made by the independent bench. Many of them are deserving, careful, and thoughtful, and should be weighed against the urgency of the moment. But this is no ordinary piece of legislation. We need to get this on the books right away. The government is unable to accept amendments to the legislation. this afternoon. We do, however, commit to a continuous process of engagement with the independents in particular, and we'd like to discuss with them a structure in which that could take place. Mr. President, with those few words, I beg to
Honorable Senators, the question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a second time. Those in favor say aye. Aye. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Yeah.
Titled, An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters.
Honorable Senators, I would like to propose that before we get into the committee of the whole Senate, that we take our tea break at this time. So when we return, we shall proceed uninterruptedly. So at this time, the sitting is suspended until 6 p.m.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the law reform Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the law reform Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honorable Senators, we have the bill that is before us has 28 clauses, one schedule, and a preamble. Now, we have before us some 7 sets of amendments by 7 senators. So we would like to ensure that the senators in question would be seized of those amendments that are before us, so that everyone would be conscious and aware of those amendments. We have Senator Dr. Desiree Murray. She has some amendments before us. We also have Senator Michael de Lavastide. We also have Senator Marlene Atz. That's 3. We have Senator Anthony Vieira. 4. We have Senator Lolita Etienne, number 5. We have Senator Foster Cummings, number 6. And then we have Senator Faris Alwari, number 7. Just want to make sure all members would have in their possession these 7 sets of amendments. Now, we are going to proceed with these clauses, with the bill, I should say, clause by clause. And when we reach the particular clause where there are amendments from either 1 or 2 senators, we shall pause, take the amendments, allow them to articulate those amendments, and we'll put it to the floor thereafter. Yes?
May I, for your guidance, and then perhaps an effort to make this easier, if I may inquire, I heard the Honorable Attorney General in his proceedings, in his wind-up, indicate that we probably in a position of not taking any amendments. If so, and appreciative of that position, I would propose, for example, in my own amendments, merely to state them for the record, not by way of any debate or other position, but it would help us to understand whether there's room to push or not. So I was just hoping for your guidance through you, Mr. Chairman, so that we can perhaps at least have the record perfected as opposed to any argument on it.
Yeah, well, I'm happy that you raised that point because having regard to what the Attorney General indicated in his closing remarks, I would have liked to get from our senators whether they would like to pursue their amendments or whether they would like to withdraw their amendments in light of the fact that the Attorney General has indicated that the government appears not to be, I wouldn't say interested, but they would not be acceding to any amendments during this period. Am I correct, Attorney General?
Chair, I hate to correct you, but I don't think that I used that language. What I said was that there were a number of factors.
Yes.
I will try to impart this. One, the fact that we are maybe 72 hours away from the end of the state of emergency, and we wish to have something in place by then. Two, the fact that there are a number of what appear to be very substantial and these are not amendments that one can dismiss. They are amendments, substantive amendments, which require some careful thought that the legislation is really what we would describe to be a model law, that even what might appear to be the most straightforward amendments, we wish to have technocrats, and by technocrats, I tell you what I mean. The police who got a raw deal here today, in my view, the Chief of Defense Staff, the intelligence agencies, all of them have helped all of them are stakeholders in this. Of course, the Law Reform Commission. And the 50 amendments the bill has generated a great deal of interest, so that you have a number of senators making a number of suggestions. As I say, some of them seem to me to be very attractive, but you have an interplay between the amendments which those senators have made and other senators have made. It is difficult for us, and we've taken the policy decision that the bill will, there are a couple of options open to us, and insofar as this piece of legislation is concerned, we would like to pass it as is. We do not go back to the House of Representatives until Friday. We like to pass it as is. Look at perhaps a way to engage with senators. I heard a suggestion from Senator De La Bastide. I'm not sure how, I've been in the Senate for a while. I'm not sure how that works. I had an excellent working relationship with Dana Sitahal, but that was because we were friends. I'm not sure how it works in terms of liaising with the independent bench, but we would like to develop some sort of mechanism. Yesterday in Joint Select Committee, I had a really good exchange with Senator Vera. Some mechanism in which we could exchange views and decide, well, okay, this is a red line for us. This is not. This is something that we could be flexible on. So we aren't there to, we are nowhere close to that this afternoon. We will not be close to that before the 31st, and something will have to be put in place on the 31st. That is what our intelligence agencies tell us. So the Senator Arawi is correct in that we are not able to take amendments this evening. And I apologize for that, because that is not the way we normally do business. But then this debate has gone on for a considerable period of time. Part of it, I'm not, I don't want to take ownership, but I have not been here for some of that time.
Okay, thank you. Senator Vera.
Thank you. Thank you, AG, for making that clear. Just for the record, two things. I personally am disappointed. When I listened to you and Minister Sturge initially, I was under the impression that the government might have been open to taking amendments. And I know all of us worked very hard in trying to put forward the best amendments we could in good faith. Secondly, we do recognize that there's a lot of repetition. So we have tried amongst ourselves to see if we could cull amendments that were overlapping with each other so that things would move along briskly and avoid tedious repetition. And last but not least, I don't think we'll be engaging in much debate. I think, like Senator Alwari, we will simply put our recommended amendment on the record and move on from there.
Okay. All right, well, we have 28, as I said, clauses, one schedule, and a preamble.
One more question for guidance, please, yes. Mr. President. Mr. Chairman,
yeah.
In drafting my own amendments, I have gone in sequential order, beginning with preamble, which is the last in the normal course of things, and I've suggested insertion of several new clauses. Would you, in tabling these matters, guide me on when it will be appropriate to table what are new versus what is to come at the end? So, for instance, you may begin with clause 1, I may have a new clause 2, but you may take those clauses towards the end. So if I may, for the record, rely on your guidance as to when I can put those submissions on the record. Thank you.
Yeah, I think what you have said is quite correct, and I think we should proceed along those lines. So, as I said earlier, and we can probably commence, we have 28 clauses in the bill, one schedule and a preamble. And we can all agree that the first two clauses before us seem to be a bit harmless. There are no amendments, that is, to those two clauses. Am I right? Clauses 1 and 2. All right, but let's see, we just close 1.
Yeah, just close 1 and then we do close 2.
Okay, so Senator Alvaro, you have an amendment to clause 2.
Yeah,
so
I would be withdrawing that one. Yeah.
Let's deal with clause 1.
Sure.
All right, so let's go.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stands part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. Senator Alwari.
Mr. President, I withdraw my proposed amendment to clause 2. Thank you.
All right, so Senator Alwari has withdrawn is amendment to clause 2. So the question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. I think there is an amendment to clause 3 by Senator Anthony Vieira.
Very briefly, clause 3 provides a blanket constitutional override of sections 4 and 5 of the Constitution. While section 13 permits this, a blanket override raises concerns about proportionality, necessity, and long-term precedents. I felt that derogation should be specific, not general. Parliament should be clear about which rights are limited and why, and limits should be no broader than strictly necessary. The proposed amendment seeks to narrow and articulate the override accordingly. Thank you.
General, would you like to respond to clause 3? The amendment?
We'll note it.
The question is that clause 3 be amended as circulated by Senator Anthony Vieira. Those in favor say aye. Aye. Those against say no. No. Clause 3. Clause 3 will not be amended as circulated by Senator Anthony Vieira. Is that clause 3 as amended? Now, clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Chair.
Clause 3 now stand part of the bill.
Chair, when I said that I would note it, I did mean that I would note it. I meant that I would consider it. So I know that for the purposes of the bill and the exercise that we are engaged in, that we have to do our business. But we have flagged, the technocrats have flagged it, and I will consider it going forward. I'm not sure what the mechanism would be. I just want to say that.
Okay. So usually when you said you'll take note of it, you'll come back maybe subsequently.
Yes. So
with maybe an amended version later on.
We will look at it. We'll consider it.
In the future. Right? Okay. Okay. Thank you. So, yeah, clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 now stands part of the bill. We have Senator Jeremie.
Thank you, Mr. President. Mr. President, for clause 4, I thought it would make neater sense to just simply define minister in the interpretation clause, because it's just repeated throughout as the minister with responsibility for national security. So it's usual to put that definition in the clause. Thank you.
Attorney General, would you like to respond?
That I do not agree with, Chair. We regrettably, we don't think that it is required.
Clause 4 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. The noes have it. I think the noes have it. Close. The question is that clause 4 now stands part of the bill. Those against say no. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stands part of the bill. Senator Alwari?
Thank you, Mr. Chairman. Mr. Chairman, the rationale behind the amendments that I have proposed for clause 5 oscillate around the fact that emergency powers of this type are usually in our Constitution solely vested, in our Constitution solely vested in the President. In 2017, when the law reform had drafted the bill taking its first pass at it, we had included that it would be the President who would be the originator of these types of powers. For these reasons, in Clause 5, I propose 4 respective amendments which treat with that principle, where we propose that it is the President on the written request with reasons of the Prime Minister and Council to declare an area zone. The reason why we're requesting the written reasons of the Prime Minister is to shore up the proportionality that can happen with due process, particularly with judicial review, so that reasons can be discoverable. It would give us the manner akin to the emergency powers where a statement of Her Excellency the President is debated. Particularly in the second amendment proposed, we specifically propose that police powers are left to the police. And in Roman 2, in deleting paragraph 2 and proposing a new paragraph C, we're proposing that the objects of the bill are to allow the police to conduct law enforcement and exercises in zones, and that they may do so with the aid and support of members of the Defence Force, who themselves shall not exercise police powers. And that is taken from the root of the Police Service Act, Chapter 1501, Section 43, which allows the police to call in aid assistance, and also under common law in the comitas principles that exist there. The next amendment, similarly, is to allow police to search a person or vehicle without a warrant, again with the aid of the Defence Force. The further amendment in Roman 4 is to allow the police to arrest or detain without a warrant, again with the aid and support of the Defence Force. The reason that we propose that we cleave the Defence Force out of exercising police powers is because we hold the view that the Defence Force answers to the Minister of National Security and the Defence Council, which is chaired by the Minister. There is therefore, in the sense of the Hines case principle and the principle of Lord Diplock, no service commission of the type to protect against the use of an army for the personal or use of a political purpose. I don't mean that against this government per se. I'm using from the dicta of Lord Diplock. It is for those reasons that we propose, therefore, that it would be by far a more legitimate aim and rational proportionality connected with our constitutional exceptions that we give police powers and move away from the defense. We agree that the Defence Force may be used in aid of police support, as they have been used for years in joint commands, in joint actions, but in those circumstances, the police alone exercise powers. The last thing that I would say here is that the Constitution is constructed, in our respectful submission, such as to allow the President and only the President to be the Commander-in-Chief of the Armed Forces. It is constitutionally, therefore, an aberration to insert the Prime Minister, whether in council or not, as the Commander-in-Chief of the Executive Forces, therefore raising serious issues with the constitutionality. I've accepted that the Honourable Attorney General has already answered some of my submissions in a very brief form in his winding up. I don't propose to enlarge the debate. I make these comments for the purposes of the record in the event that it needs to be used in aid of other proceedings. Thank you very much, Mr. President. Mr. Chairman.
Chair, I have spoken to this before. The power of the President is largely ceremonial, including her power as Commander-in-Chief. This is not a state of emergency, of course, in respect of which she does not act alone. The need for speed and the need to have an effective law legislation, this is not state of emergency in place, requires, in our view, that the Prime Minister in council, which I'm happy that Senator Arawi was forthright enough to say it may have been in his earlier draft. His later draft has the Prime Minister, not the President, and that we prefer to stick with that. So I've already expanded on it.
Okay. All right. Honourable Senators, the question is that Clause 5 be amended as circulated by Senator Alwari. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 5 now stands part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that Clause 6 now stand part of the bill. I see we have amendments from Senator Vieira, SC, Senator Michael de la Bastille, SC, and we also have Senator Alwari. In that order, Senator Vieira.
No, I believe Senator Arts too, Chair. I think she goes before us. Yeah.
That is Clause 6.
Yes, Chair.
That's a new clause. That will come later.
Will come later, okay.
Yeah, new clause.
Okay.
Right.
Thank you, Chair.
Yeah.
The terms rampant criminality and threat to the rule of law and public order are undefined. And I accept that flexibility is necessary, but undefined discretion invites allegations of arbitrariness. It can fuel claims of political or racial targeting, and it weakens judicial deference if challenged. My proposed amendment seeks to define these terms by reference to objective indicators such as crime, data, firearm prevalence, organized criminal activity, enforcement, failure. It seeks to preserve executive discretion while structuring it, and it aligns with administrative law principles of reasonableness and relevance. I do believe objective criteria protects the executive as much as they protect citizens. They make decisions defensible, not weaker. Thank you.
Senator Michael de la Bastille.
Thank you, Chair. Thank you, Chair. Chair, I just take this opportunity to say that based on the other proposed amendments and based on the comments and statements of the Honourable Attorney General with respect to amendments, I'll be withdrawing all of my proposed amendments except for when we come to Clause 22. So I'm sure everybody will be happy about that.
Thank you very much, Senator Labasi. Senator Vieira.
Thank you. As we were looking at 6, I had 2 amendments. One was for 6.1a and then 6.3. So I don't know if anybody else wants to speak to 6.1a. I can wait, but I just have a 6.3 also to speak to. Thank you.
You can speak.
6.3 goes to clarifying the criteria for zone selection. The bill doesn't currently require decision makers to consider whether less intrusive measures are available, proportionality to the threat, or the impact on law-abiding residents. So the rationale for the amendment is by requiring the Prime Minister and Council to have regard to necessity, proportionality, alternatives, and community impact, the amendment would embed constitutional culture into decision-making and counter claims of arbitrariness, and hopefully strengthen the bill against judicial review.
Senator Alwari, you have some...
Yes, thank you, Mr. Chairman. Mr. Chairman, I have proposed 6 amendments to clause 6 as originally numbered, and if I could go through them in series and succinctly. The first thing is that in agreement with submissions for other reasons, but other senators have raised the issue of the vague aspects of interpreting rampant criminality and threat to rule of law. So I've sought to join them to say in 6.1, where there are reasonable grounds to believe that there's rampant criminality, gang warfare, escalating violence and murder, so as to be a threat to the rule of law and public order. I've taken that approach, borrowing the language of the emergency powers run up to the wicket in the Constitution, which sets out, we consider that the simple split of the threat to rule of law and public order is by itself simply too vague and can lead to potential abuse. Again, speaking in the abstract and not pointing a finger to anyone. The second thing is that borrowing from the 2017 draft of the law and borrowing from the Jamaican Act, we have proposed that we insert that there is the written agreement and advice of the Commissioner of Police and Chief of Defence Staff. This would be so that you would insulate a Prime Minister from an allegation of political activity as opposed to law enforcement activity. Again, because in our humble submission, it is not the role and function of a Prime Minister to be a person who triggers powers such as this. It's not found in our law, is our submission. The Constitution provides that the President is much more than ceremonial in our respective view, that the President, when acting in the Constitution, whether under Section 80 of the Constitution or otherwise, may do so in his own discretion. And again, we say that the President may, after due consideration on the written advice and reasons of the Prime Minister and Council, declare any geographically designed area. Borrowing from our 2017 draft and from the Jamaican law, we consider 180 days to be too long a period, and we have proposed 60 days because this is an entire period during which there are emergency-type powers and privilege given to the defence force to act where they don't have powers and privileges of the police in law. In the third amendment that we propose that one ought not to be in the position of declaring the whole of the island of Tobago or the whole of the island of Trinidad as zones by themselves, but that one may have parts of both islands declared. This is to give rationality to the precedent that we have in the disaster measures legislation, and therefore to make sure that we weren't really using a backdoor substitute for constitutional states of emergency. One ought not to have the whole of the island of Trinidad or the whole of the island of Tobago. We have also proposed, in keeping with our submission, that the President is the one who makes the order, that within 3 days of making the order, the President shall deliver to the Speaker for presentation to the House a statement setting out the specific grounds on which the decision to declare a zone was based, and shall fix a debate for that statement and for the affirmative resolution of the House. We do that, Mr. President, borrowing from the precedent that we have in sections of emergency power in the Constitution, and again, keeping the exercise of executive power, in our view, pursuant to Section 74 of the Constitution, in the hands of the President of the Republic. The last thing that we do is, second to last thing that we do is to say that unless the order is previously revoked, it shall last for 15 days, so it gives regularity. In proposing this course, and in having the statement of reasons and the affirmative resolution, it would remove, in our view, all doubt of constitutionality, and it would ensure against judicial review going in the wrong direction for a government that wanted to uphold a special zone of operation. The last position was a backup plan for discussion, that if one wanted to avoid an affirmative resolution route, as proposed in Roman 4 of these amendments, that the Attorney General could have considered instead a negative resolution by the Parliament, which is in keeping with another aspect of the bill. These are my submissions as to the amendment to Section 6, again driven to shore up the constitutionality, allow police to exercise police powers, allow the President to insulate the government from any allegation of political potential abuse, and to shorten the timeframes and regularities of the period. Thank you, Mr. Chairman.
Attorney General,
Chair, I would like to consider again Senator Vera's points. I disagree that and I'm repeating myself, that the President is anything but ceremonial insofar as her powers as Commander-in-Chief of the Defense Forces are concerned. If one draws a reference to the United Kingdom, it would be a constitutional heresy for there to be an issue of any type, national security issue, in which the King or the Queen, as the case may be, decides that she's sending the SSE or whatever you call it, the SAS, to go raid somewhere. It's just not done. So I don't want to use, stronger language than to make the point that even in respect of a state of emergency, I know it because I have done it before. The Senator knows it. The President acts on the advice of the Cabinet and is very careful to ensure that her actions align with the reasons given by the Cabinet for the declaration of the state of emergency. So I disagree with that. So that's it.
Mr. Chair, is there a possibility that you would allow me to ask a question? And it's directed to the Honorable Attorney General. In the light of Senator Vera's proposed, what would have been his proposed amendments, my question is, how is it in the drafting of this Section 6, where the power is specifically being given to the Prime Minister in Council, how come in this section there is no protection, as it were, for the Prime Minister, or insulation for the Prime Minister, the person making that kind of order, by building in these conditions or conditions similar to these? How come that's not here?
In these conditions,
So essentially, when you want to show that you're acting proportionally or you're acting reasonably in all of these circumstances, you show that you are ticking the right boxes.
Correct.
But there is a sort of very broad, the language of this section is very, very broad and makes it easily challengeable for that very reason.
I disagree with, not I disagree. Senator Arawi is wrong when he says that there are written reasons in Jamaica. The act in this respect is a mirror of the Jamaican statute. Now, one can say that there ought to be criteria, but those criteria are not set out in the Jamaican statute. The Jamaican statute is what is repeated here and what Senator Arawi had produced.
Sorry to interrupt, AG, through you, Chair. I wasn't concerned with what Senator Al-Rawi had said at all. And I know that you're saying that this is a case in Jamaica, but I was thinking, well, if we are legislating, shouldn't we be producing the best legislation then? And certainly I found myself having a lot of sympathy with what Senator Vera had proposed.
So,
it seemed to be a rational approach to it.
Right. So did I, and that's why I made the point that that is something that I would consider. So I would have to circle through my stakeholders, but my point was with respect to...
Mr. Chairman, in a very succinct position, as the proposal is my proposal that we're considering, and it would be usual for me to make the statement at this point. Just for the record, Section 4, subsection 6 of the Jamaican legislation specifically says, have agreed in writing that the area should be so declared on the part of the Commissioner of Police and the Chief of Defence Staff. It does not provide for reasons, which I have included in this draft, but for the record, I've suggested reasons for the insulation of the Prime Minister against judicial review. I just want to make it clear that I'm deliberately attempting not to use any caustic language so that I can keep the points as succinctly as I can for the benefit of the record. But for the record, I would like you to note the constraint that I'm putting here. So I have been faithful to what I said the Jamaican law has. I can produce it for you. It's in writing. So just to put it on that point by way of the final submission.
The question is that Clause 6 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. The noes have it. The question is that Clause 6 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 6 now stands part of the bill. Right.
Clause 7.
The question is that Clause 7 stand part of the bill. We have two amendments according to what we have before me. Senator Dr. Atz and then Senator Alwari. In that order, Senator Atz.
Thank you, Chair. At this time, I wish to withdraw my proposed amendment under Clause 7.
Okay, thank you very much, Senator Atz, Dr. Atz. Senator Alwari, please.
Thank you, Mr. Chairman. Mr. Chairman, in Clause 7, I propose 4 amendments as set out. The first amendment is to seat the Prime Minister in Council making a declaration for a variation of a zone, whether in time, geography, or extent, or otherwise, after consultation with Joint Command and where the Commissioner of Police and Chief of Defence Staff agree in writing with reasons. The in writing is borrowed from the 2017 draft and the Jamaican legislation. The reasons is new. That is intended to provide a shore-up of protection for the Prime Minister to protect us in judicial review proceedings and otherwise. It again locates the authority to the President, who may, after due consideration, subject to the law, extend as has been suggested. We propose in the second amendment to Clause 7 that within 3 days a statement is made, that statement gives the reasons and is presented to the House for debate for affirmative resolution. It's in keeping with the bill as it's tabled in Clause 7, where an extension is done by affirmative resolution. In the circumstances, we've sought to marry the provisions, borrowing from the approach that is used in the Constitution. We propose, in keeping with our 2017 draft, as well as the Jamaican law, that the time frame be reduced from 180 days and kept at 60 days and no longer. And then we propose that we delete clause 7.3 as originally numbered, and that is specifically, Mr. President, so that we could marry the amendment taken care of in the first position. We've done that in keeping for the submissions that we've offered in relation to clause 6, which I won't, in the interest of time, repeat, but which I rely upon. Thank you.
Okay, the question is that clause 7 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 7 now stands part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill. Senator Dr. Atz, you have an amendment here.
Thank you, Chair. I wish to withdraw my proposed amendment to clause 8.
Okay. The question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Oh, you want to say something? Yes, sir. Okay.
Yeah. Thank you, Mr. President. For the record, I had proposed, in keeping with my amendments above, that clause 8 be deleted because we had proposed that the affirmative resolution be part of clause 7 as amended. Thank you, Mr. President. Thank you, Mr. Chairman.
Be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that clause 9 stand part of the bill. Senator Alwari.
Thank you, Mr. President. Mr. President, clause 9 of the bill we propose be amended as circulated. In clause 9, as it's originally put, it's that the Prime Minister in Council may, on his own motion or on the recommendation of Commissioner of Police and Chief of Defence Staff, revoke an order with the declaration of a zone. We propose instead that the order declaring a zone may be revoked by the President, again in keeping with the centrality of command and the Constitution with respect to the Defence Force, after due consideration, acting on the written advice of the Prime Minister, who in turn must receive the written recommendation of the Commissioner of Police and the Chief of Defence Staff. To put the Prime Minister on his own motion is to suggest that the Prime Minister has the authority to deal with criminality which our Constitution does not permit. The police can deal with criminality. The President may declare a state of emergency, but in no circumstances can a Prime Minister invoke those powers in our respectful submissions. For those purposes, we've sought to bring it back to the President, and borrowing from the Jamaican precedent, we've directed ourselves to the written recommendations of the Commissioner of Police and Chief of Defence Staff, protecting the Prime Minister from any claim of improper conduct, particularly on judicial review, because a Prime Minister would be able to rely on those reasons. Thank you, Mr. Chairman.
I don't want this to be a back and forth between Senator Rawi and I, but I don't wish to read the Jamaican section. Suffice it to say that it does say the order declaring a zone may be revoked at any time by the Prime Minister in Council. We prefer to keep it as it is for the time being.
Let me with the question. The question is that Clause 9 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill. Senator Dr. Arts and Senator Alwari, in that order.
Thank you, Chair. I wish to withdraw my proposed amendment to Clause 10.
Senator Alwari, the floor is yours.
Thank you so much, Mr. Chairman. Mr. Chairman, Clause 10 of the bill we propose be amended in three respects. Clause 10 of the bill, in our respectful submission, is a critical point that deals with the discipline of the rank and file of the joint force. We propose, firstly, that Clause 10.3, which says that every zone shall have a written accountability and reporting system as specified by the National Security Council, we go to particulars there, borrowing upon the jurisprudence coming out of the COVID and the Ministry of Health challenges, where our courts held that there must be publication of rules, regulations, and directions and standing orders in the COVID manner. This is the funeral pyre cases, just to remind you, Mr. Chairman. We've borrowed from that learning where the court says that there ought to be publication of these to say that every zone shall have standing orders to establish a written code of conduct to govern any member of the Joint Command and Joint Force, which includes an accountability and reporting system as shall be made by the Minister, meaning the Minister with responsibility for national security, upon the advice of the NSC, after consultation with the Commissioner of Police and Chief of Defence Staff. We do that because we're dealing with two separate pots of authority, the Trinidad and Tobago Police Service and the Trinidad and Tobago Defence Force. And then we say, critically, that it must be published in the Gazette and twice in 2 daily newspapers in wide circulation. And also, we've added the web pages of Trinidad and Tobago Police Service. This is to give notice to the world, apart from legal notice in the Gazette, and therefore it would allow for accountability of persons who go afoul of the law. Because it is later in this clause, it's later in the Act that you see, it's here at subclause 5 in Clause 10, you see a person who fails to comply with subsection 4 is liable to disciplinary action. In our view, you can't be liable to something that you don't have notice for and that the world doesn't know it ought to bring you up on disciplinary charges because they've never seen it gazetted, it can be changed, there's debate. So we think that the absolute axiom of publication and gazetting is required. We then propose that, in addition, we propose, following upon that, in Clause 10.4, that it be substituted by, in addition to such other compliance required of police members and the Defence Force under any other written law. In preparing this, I went to the Police Service Act and the Police Service Regulations and their standing orders, and I also went to the Defence Act and to the Defence Force Regulations, and I can say that in my experience and sitting on the Defence Council for 10 years, I felt that it was important to include that you could be subject to breaches of the law apart from disciplinary action alone. So we have preserved the fact that it may be that you are required to be in compliance with other laws. If you look to the last amendment, it follows from what I've just said. Notwithstanding that he may be charged with an offence under any other written law, any person who contravenes subsection 4 commits a disciplinary offence. It therefore avoids any risk of implied repeal or of immunity being offered and a reduction of offences being there. It is to avoid the argument. I've borrowed specifically from the Defence and Police Complaints Authority Bill of 2013, which the UNC brought to Parliament many years ago, which did not pass, but which had similar wording to this. So in summary, Mr. Chairman, this is intended to have the publication of regulations, standing orders, guiding principles. It is to allow the population to have notice of it, both legal and actual. It is to allow for the bifurcation and maintenance of both disciplinary and criminal charges, and it is to be cleaved between the TTPS and the Trinidad and Tobago Defence Force. Thank you, Mr. Chairman.
Yes, Senator Vera.
While we're still on clause 10, just wanted to flag what I see as a constitutional weak point. The National Security Council is not a creature of statute. It is an executive committee of the cabinet. Unlike the Defense Council, it has no legislative framework, no defined powers, no statutory limits. And now this matters because the bill repeatedly vests authority in the Prime Minister in Council and the National Security Council, including declaring zones, designating joint command, suspending operations, receiving operational reports. And this creates, in effect, a parallel command and control structure not expressly contemplated under either the Constitution or the Defense Act. Now, so I see this as a structural constitutional problem. Reporting under the bill is to an executive body chaired by the Prime Minister, the same body that declares the special zones is going to receive the operational reports, and you're creating a closed executive loop. Unlike Jamaica, we don't have a national security advisor. We don't have a robust independent National Security Council Secretariat, and this weakens external security. Thank you.
I do think that we have a robust National Security Council. I take the point that it does not have a personality per se, but it is a subcommittee of the cabinet. And the cabinet has obviously oversight for decisions of the NSC. It has spending autonomy, vast spending autonomy on its own without reference to the cabinet. Now there's a case, the GCHQ case, which says that generally speaking, decisions of the national security are not reviewable or reviewable. The courts give a large margin of appreciation with respect to matters of national security. But I take the point. It's an interesting point. I'll pay attention to it.
Mr. Chairman, just to wrap up now, in the closing of the submission, if there are no others, as it's my amendment, I'm not sure if anybody else wishes to contribute. Thank you, Mr. Chairman. Mr. Chairman, I was saving it for reply, but it's the reason why I had inserted the word minister, because I accept what the Attorney General is saying as the Cabinet's general authority, but I remind that it is usual to have a minister make certain rules and regulations, etc., hence the Minister of National Security. I'm cautious as well that the Freedom of Information Act can be applied such that you can disallow disclosures of the National Security Council. If it comes from the TTDF, you can seal reports and they would be rendered without discovery. It's for those reasons, again, that in the closed loop, if I borrow Senator Vera's submission of executive authority, that we didn't believe that it is in the best interest of the constitutionality of the law to have the control of police powers vested in a cabinet, particularly in a subcommittee. I've heard the Honourable Attorney General, and I don't propose to be in a debate, but those are the submissions.
I'm sorry, Mr. Chair.
Yes.
One, if you would permit me, one small question to the Honourable Attorney General. The GCHQ case to which you refer, is that not the case that has to do with the deal with the interpretation of the English Official Secrets Act? Is it the same GCHQ case we are talking about? And that legislation said that it wasn't reviewable, and in any event, that was in the 1980s.
Security, and it says that in respect of national security, the executive ought to take a hands-off approach. But it is the case.
Yes, agreed. Thank you.
Clause 10. The question is that clause 10 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. I think the noes have it. The question is that clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that clause 11 be amended in two aspects of the law. First of all, we propose that whereas clause 11 proposes that the Joint Command should submit a written report to the National Security Council only, I'll add that, every 30 days, we propose that the report be submitted to the Council, the Commissioner of Police, and the Chief of Defence Staff. This is specifically intended to shore up the constitutionality. Why? Under sections 122, 123, 123A of the Constitution, the Commissioner of Police is bound to report to the Police Service Commission every 6 months and otherwise, or on matters that they may seek to discipline a Commissioner of Police or a Deputy Commissioner of Police in respect of First Division matters. Secondly, the Commissioner of Police would have the ability to discipline pursuant to section 123 of the Constitution orders and officers in rank below him having management and discipline that way. This would conform with the regulations. If these reports, for instance, from the Defence Force went only to the National Security Council, or the Commissioner of Police went only to the National Security Council, and there wasn't reciprocity, particularly where the bill proposes that the Defence Force exercise police powers, then the left hand may very well know what the right hand, may not know what the right hand is doing. And more than that, because the National Security Council has no legal status, I should say statutory status or constitutional status, other than by way of being a subcommittee of the Cabinet, and not all national security notes, council notes, go to the Cabinet, we are going to possibly have a vacuum of information and therefore a vacuum of discipline, responsibility, or otherwise. We also propose, insofar as we had made the amendment that we moved down from 180 days, we'd made a concomitant position of a review and submission of reports every 10 days, keeping with other legislation that we have borrowed that expression from. So this was intended to shore up the constitutionality. Particularly, later on you'll see, Mr. President, we have suggested that the Trinidad and Tobago Defence Force, where it is engaged in a joint command, that it is not subject to the Defence Council or the Minister's supervision, because the Defence Act allows, well, says in Section 5 of the Defence Act that the Defence Force is subject to the specific or other or general directions of the Minister. So we had delinked that to say that the TTDF would be insulated and stand apart from the Minister's general or specific control. So all of this is done with a view to ensuring accountability and constitutionality. The second amendment is again to take into account the fact that it ought not to be that if you breach these positions, you are just liable to disciplinary action. We've sought to include the language which says, notwithstanding that he may be charged with an offence under any other written law. And by that, of course, I'm referring to the suite of laws that govern police, because I would remind that police include TTPS, supplemental police, supplemental reserve police, special reserve police, and municipal police. So in those circumstances, we wanted to make sure that all the regulatory laws and offences applied, as well as those that prevail in relation to the Defence Council and the common law. Thank you, Mr. Chairman.
Okay. All right. Let me put a question. The question is that Clause 11 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 11 now stands part of the bill.
Clause 12.
The question is that Clause 12 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that Clause 12 be amended such that the Prime Minister and Council shall, on the written recommendation of the Commissioner of Police and Chief of Defence Staff, have the power to suspend operations of the Joint Command. This is specifically to insulate the Prime Minister from any allegations of improper conduct, to be acting upon the advice and authority which would allow for judicial review or other circumstances, so that we could defend against any activity that could be deemed to be other than democratic or otherwise. And I rely upon the reasons given earlier in respect of a similar amendment.
Attorney General, any comments?
I know it's late in the day, but isn't that what the section says already? The Prime Minister may suspend on the written recommendation of the COP and the CDS?
EG, you're correct, but it removes the sole discretion where the Prime Minister and Council, or where the Prime Minister and Council considers it necessary to do so. So we kept with Part A, we deleted Part B, because Part B would leave the Prime Minister and Council on his own, and therefore, without the benefit, it would lead one into the allegation, which could be fed, that a Prime Minister was somehow managing law and law enforcement.
But this is not, this is the opposite of imposing a zone. This is lifting the zone. So, I mean, I don't see how...
I have an answer, but won't give it so that we stay to the brevity of the engagement.
It's the opposite of a right.
I could have said the same thing in respect of other things, but I've kept quiet on the undertaking that we keep it brief.
Clause 12 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that Clause 13 now stand part of the bill. Senator Alwari SC.
Thank you, Mr. Chairman. Mr. Chairman, we propose that the Minister and not the National Security Council, why the Minister is given responsibility pursuant to Section 79 of the Constitution, and therefore we've gone to fix the entity that is known in law. We've not taken the proposal of the National Security Council for the same reasons offered earlier about it being a subcommittee of cabinet and without constitutional or statutory provision, accepting what the Attorney General has said as to general cabinet, well-known authority and responsibility. We've said that the Minister shall, on the written advice of Commissioner of Police and Chief of Defence Staff, make a written code, and as opposed to just saying that the code must be in existence, which is what the bill says, we've demanded that the code be published and gazetted, specifically so that A, it has legal authority by way of notice, B, that it is brought to the attention of persons who may wish to activate their rights, and C, so that there is some regularity in the purpose, particularly when it comes to judicial interpretation, and one is asking the question, well, which is the right thing? Version 1, 2, 3, or the one that can't be found? So for those reasons, Mr. Chairman, we propose that Clause 13 be amended as circulated.
I think this is the clause that I would have a serious problem with. You're asking us to publish the names of the officers involved in gang interdiction, gang activity, and to put them in a gazette. I don't see the sense in it. And I mean, I'm sorry if I used intemperate words there, but that is something that I would have a great difficulty supporting.
Thank you, Mr. Chairman. Just in closing, Mr. Chairman, that is not what I have suggested at all. The Minister shall, upon the written advice of the Commissioner of Police and Defence Staff, establish and make written code to determine the method by which the identity, a method may have an anonymous approach, A method may have badge numbers as opposed to other positions, but to hear that the risk of the personalities is in the equation is to raise the severity of our concern, because the Trinidad and Tobago police standing orders and the law allow persons to be with the benefit of the identity of the persons carrying out law enforcement. Badge number, name, usually where warrants are done, the warrant is shown. In fact, you can pull out your phone and record the entire incident. Now I have the apparition of masks and doors being broken down, which cause me great concern, but that is not what I am suggesting at all. This is the method by which, and so that there is transparency in law enforcement, Mr. Chairman. So just to draw the distinction between what the Honourable Attorney General perhaps understood a version of what I said to be, I'm clarifying that that is not it, but his input has caused me even greater concern as to the identity being capable of being found. The last thing that we would want is hooded people exercising the powers of the police where they don't even have it.
Yeah, the question is that clause 13 as amended, be amended rather, as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clause 14.
The question is that clause 14 stand part of the bill. Senator Vieira, SC.
Chair, before I go to my proposed amendment, with your leave, may I share some good news to lighten the moment? I've been informed that Trinidad and Tobago just became the 19th state party to the Escazú Agreement. We have just deposited our instrument of accession at the United Nations. So, heartiest congratulations. Well done, government. Now, my amendment seeks to clarify the supporting role of the Defense Force. The bill permits Defense Force personnel to exercise the powers of a constable in zones, but it does not require police equivalent training, does not require certification, does not expressly preserve the supporting role of the military. And I believe this creates serious risks. Abuse of powers through unfamiliarity with policing standards, evidential failures in court, civil liability, and unhealthy long-term militarization of public order, which I spoke about in the debate. My amendment seeks to require the Defense Force personnel to receive approved law enforcement training, require written certification by the Commissioner of Police, limits certification to the duration of zone operations, and clarifies that military involvement is supportive, not substitutive. If we give soldiers police powers, we must also give them police training. Anything less is unfair to them and is dangerous to the public. Thank you.
Can I ask Senator Alwari if he has any comments on to make on?
Yes, Mr. President, I have a number of amendments I've proposed. So, Mr. President, we propose 5 amendments to Clause 14. Clause 14 is, for me, the nuts and bolts of where the mischief in this law lies, in its most apparent way. It, of course, exists in other places. Clause 14, as it's currently set out, is that the Joint Command may establish a cordon, and in the second aspect of that, the Commissioner of Police and Chief of Defence may impose a curfew. It then goes in to say that notices shall be produced in certain aspects. The second aspect of Clause 14 is that it says, for the avoidance of doubt, where a cordon is established or a curfew is imposed, any member of the joint force may, for purposes of enforcing such cordon or curfew, exercise such powers as are vested in a constable. With respect to the amendments circulated, we propose, A, with respect to the cordon, that a cordon may in fact be established by the permission of the Commissioner of Police. So we suggest that the Joint Command may in writing request the permission of the Commissioner of Police to establish a cordon, and that as soon as practicable after the commission may be granted, that a notice is set out. It must be published in the Gazette. It must be published in 2 daily newspapers in wide circulation, and it must be on the web pages of the TTPS and the Ministry of National Security. We also say that you may publish in any means possible. We've borrowed this language from the manner in which SOEs and curfews are done under state of emergency regulations, which can be done under the Commissioner of Police's hand. Under a state of emergency, the normal state of emergency curfew aspects, even though I'm speaking about cordon, are delegated to the Commissioner of Police in states of emergency. We think that publication is critical, again, to have certainty for the enforcement of law in the reciprocal arrangements of rights, those who are enforcing the law and those who may complain about the enforcement of the law. Similarly, in respect of a curfew, we say that the Joint Command may in writing again request the Commissioner of Police to impose a curfew, and that the Commissioner of Police may agree to that, again with publication for legal certainty for the reciprocal enforcement of rights. Critically important, our Second Amendment says, for the avoidance of doubt, whenever a cordon is established or a curfew is imposed, members of the defense force who are members of the joint force, that is so you have certainty of characteristic, may, if called upon to assist any member of the police service in maintenance of law and order, and while such member of the defense force is engaged in so doing, shall be under the command and control of the Chief of Defense Staff. And in these circumstances, the Chief of Defense Staff shall not be subject to the general or special directions of the Minister, notwithstanding any written law to the contrary. This is a constitutional safeguard which we have developed to insulate the Minister of National Security away from what the Defense Act has placed him in. The Defense Act in sections 5, 6, and 7 say that the Defense Force is subject to the specific and general control of the Minister, and of course treats with how the Defense Council operates. This gives the political insulation away from the odium expressed by Lord Diplock in the Hines case. This is to preserve also the existing law. Section 43 of the Police Service Act allows for the aid to enforcement by any person for an officer who calls for his assistance, and therefore we were keeping this within Chapter 1501 of the laws of Trinidad and Tobago. We similarly, in our Third Amendment, instead of using in clause 14.3c, the 14.3c, where it is an officer, we're making sure that it is a police officer who exercises police powers. We've accepted that there may be a need for the Commissioner of Police to have delegated responsibility, but we have felt that an Assistant Commissioner of Police ought to be replaced with a Deputy Commissioner of Police. Why? Because the Deputy Commissioner of Police is subject to the jurisdiction of the Police Service Commission under the Constitution. We propose that 14.5b be amended, and that says that the Chief of Defence Staff may be taken, action may be taken by any member of the Trinidad and Tobago Defence Force. Because of the constitutional risk within the law's caution as the same, we believe that the Defence Force ought to be taken out of that entirely. Those are our submissions on clause 14, Mr. Chairman.
Chair, on this, I agree to consider the comments made by Senator Rawi, and definitely the training comments made by Senator Vera. I think that they have serious merit.
All right. The question is that clause 40 be amended as circulated by Senator Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 14 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 14 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 14 now stands part of the bill.
Clause 15.
The question is that clause 15 now stand part of the bill. The question is that clause 15 now stands part of the bill. Those in favor say aye. Aye. Those.
He doesn't have any amendments. He's on 16.
All right. So the question is that clause 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 15 now stands part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, clause 16 commendably ensures that seizure, i.e. police power, is done only by police officers. So I was appreciative of that fact. The amendments that we propose, which are 6 in number, are to make sure that the powers are specified. Any police powers are in fact carried out only by the police. So for instance, where you see the word joint force, we make sure that it is a member of the joint force who is a police officer that may take police power action, having preserved already the right to call for assistance from the TTDF. Similarly, if we look at 16.5, and this is by way of narrowing down the risk for any mischief, if we look at 16.5, forgive me, just let me get to the page. Yep. 16.5, the police officer shall take steps as are necessary to ensure. We have asked that it be tightened up. We take away the words, take all steps as are necessary to ensure. Simply put the square obligation to make a list and ensure a receipt is done. To do that, Mr. President, Mr. Chairman, I've reflected upon the Administration of Justice Preliminary Inquiries Act, where search and seizure provisions are put into effect into law, and in those circumstances they simply provide for list and for receipt. But very importantly, instead of confining it only to vehicles, articles, or documents, we've said items, because it may be something more than those specific categories of things. If we went to a JIPA, you see the word items is used to capture the class of things which may be seized. So those are the positions for removing those 3 words, vehicles, articles, or documents, instead items. We have asked for the inclusion of safeguards which exist in a JIPA as well. So where you have seized something, lodge a copy of the list and receipt prepared with the Joint Command and with the nearest police station, or to or in the zone, and make an entry in the station diary. In a JIPA, when you have a seizure under a warrant, it's lodged with the Registrar of the Supreme Court. So here at least we'll have the certainty of knowing what was taken within a structure that is supervised and insulated in the TTPS. We have also suggested that we need to be clear on the powers here of the aid to enforcement, and therefore we repeat that police powers essentially in a new 16.2 are to be exercised by the police, but that the defense force may be called upon to assist the members in the manner that we set out there, under the command of the Chief of Defense Staff, who shall not be subject to the general or specific directions of the Minister of National Security in the Defense Act. Those are our submissions. They're intended to improve the constitutionality and to take away the risk of Defence Force exercise of police powers without the privileges and immunities in the Police Service Act. Thank you, Mr. President. Mr. Chairman.
AG, the question is that, let me put a question. The question is that clause 16 be amended as circulated by Senator Alwari SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 16 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 16 now stands part of the bill.
Clause 17.
The question is that clause 17 now stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, we propose that clause 17 be tightened up. This is meant to be a law which would allow for law enforcement, and therefore we believe that anything seized should be for the purposes of evidence in criminal proceedings, and simply that, because after all, we're exercising police powers in seizure of matters, and therefore it should be in keeping with evidence. Specifically, in drafting this amendment, I went to AJIPA, Administration of Justice Preliminary Inquiries Act. I looked at the safeguards set out in AJIPA with respect to how things seized are managed, albeit in those circumstances under warrant. Mr. Chairman, in looking at that, we've said that, again, in clause 17.2, as we propose it is now set out, that the responsibility, in 17.1, we've taken into account of the fact that there may be some items that can't be in the custody of the police alone, so we've included a person authorized by him to receive it. That's an amendment we made in AJIPA, where things just, for instance, in IT technology, you can seize it where it is and have it kept in the custody of IT personnel, for instance, at a telecommunications authority or other method. In the new 17.2 that we put out, again, we've sought to limit it for the purposes of evidence in criminal proceedings, and that is to keep the things in safe custody. In 17.3, we've taken into account the nearly 7 years of amendments that we've had on our books, and that is where in AJIPA we've specifically provided for the use of photographs to secure evidence, as opposed to holding on to the thing, it becoming a wasting asset, and therefore having liability for compensation and return. So 17.3 is taken from the Administration of Justice Preliminary Inquiries Act. 17.4 sets out where photographs or digital recordings or other images are taken, how the returns would be done. I didn't annex to my amendments proposals for the Form 2 and Form 3 in what should be a Schedule 2, not Schedule 1, but I'm suggesting to the drafters that that can be taken from the Administration of Justice Preliminary Inquiries Act. In 17.3, we're seeking again to clarify that it must be a police officer, and again removing the limitation of vehicle, articles, or documents, and instead using things seized. We also propose similar tidying up in 17.4 and 17.5, and we are in the provisions of the last one, we're proposing that you delete no reasonable grounds referred to in subsection 3 and insert reasonable grounds to do so. So let's look at that subsection 3 for a moment. In 17 subsection 3, sorry, 6, because it's renumbered. Sorry, I'm looking at 18, 17. Right, if you look at 17.5 in the bill, a magistrate to whom an application is made under subsection 4 shall order the return of the vehicle, article, or document, as the case may be, to the applicant or to such other person whom the magistrate is satisfied is entitled to its return, if the magistrate is satisfied that there are no reasonable grounds as referred to in subsection 3. Subsection 3 is where you have reasonable grounds, you may do certain things. This just didn't read right. So I think that there's a language inaccuracy here. It didn't. I read it 2 to 3 times to try and make sense of the end of the sentence. Provided that the magistrate is satisfied that there are no reasonable grounds referred to in subsection 3, it would be much simpler if the magistrate said, I'm giving it back to you because I believe I have reasonable grounds to do so, simply. So I couldn't follow the clawback to subsection 3. Those are our submissions, Mr. Chairman.
Okay. Let's close out. The question is that Clause 17 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 17 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 17 now stands part of the bill.
Clause 18.
The question is that Clause 18 stand part of the bill. Senator Dr. Amery and also Senator Alwari, SC. Dr. Amery.
Thank you, Mr. Chairman. My amendment is quite simple. The clause says that at the time of his arrest, the person should be, as soon as reasonably practicable, be told the reason for his arrest or detention. I would like to delete unless the circumstances are such that the person should know. It's my view that everyone should be informed of the reasons for their arrest or detention, whether or not they know the reason. It's quite simple. Thank you.
Thank you, Mr. Chairman. Mr. Chairman, we propose 2 amendments to Clause 18. The first one, in keeping with the philosophy of our amendments, is that where we're dealing with a joint force carrying out an operation in a zone, the arrest should only be by a police officer. It should not be left to the question mark as to whom the officer is, because this doesn't say whether the officer is a police officer or a member of the defense force. That is to take care of the concerns in 18.1. In 18.2, we have proposed that instead of simply saying prison or police station, that we insert the words effectively, we're keeping with prison, but a child rehabilitation center, a police station, or such other place as the magistrate may order. This is because we have since passed the children's package, the children's court. This law does not contemplate with all of the amendments we made in relation to those laws that came after 2017, where the original draft of this bill came from. And therefore it would be unconstitutional to place a child in a prison. You have to have the constitutionality of the child going to a child rehabilitation center. In certain instances as well, you may wish to put somebody in St. Anne's or in a medical ward or in a hospital. So it would be unconstitutional to put that person in a prison or in a police station, in a lockup. So Clause 18 needs to have the return to the law as it's developed in relation to children and other places, child rehabilitation homes, etc. In the child rehabilitation rules that we passed, we allowed for alternative accommodation outside of children's prison, if I may call it that as well. So that's the rationale for going into a place that may be other than a prison or child rehabilitation center or a police station. Those are our submissions, Mr. Chairman.
Senator Honorable AJ, any comments? Right. Okay. The question is that Clause 18 be amended as circulated by Senator Dr. Amery. Those in favor say aye.
Aye.
Those against say no. No. I think the noes have it. The question is that Clause 18 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 18 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 18 now stands part of the bill. We have no amendments in 19 to 21. I'm taking all 3 clauses. What?
Clauses 19 to 21.
The question is that clauses 19 to 21 stand part of the bill. The question is that clauses 19 to 21 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 19 to 21 now stand part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. We have amendments from Dr. Murray, Senator De La Bastide, Senator Alwari, in that order. Senator Murray, the floor is yours.
Thank you, Mr. Chairman. Clause 22A refers to the wearing of body cameras as far as is possible having regard to available resources. So I think given the powers that the joint force will have, it should be mandatory that they wear their body cameras during the entire patrol from station and back to the station. So I think all resources should be provided for them to have the body cameras, and that's why I would like to delete as far as is possible having regard to available resources.
Thank you very much, Senator Michael De La Bastide.
Thank you, Chair. Chair, I had noticed Senator Murray's proposed amendment and Senator Alwari's at the time. I said to you I will be proceeding with my amendment to 22, but there's basically overlap there, so I'm just going to withdraw my proposed amendment.
Senator Alwari, the floor is yours.
Thank you, Mr. Chairman. Clause 22 is the clause that treats with the use of body cameras. The first thing that we wish to purge is the exception provided by the words that say, as far as is possible having regard to available resources. There are 2,000 body cameras in the possession of the TTPS, and we believe that any zone that has operations, there must be a mandatory use of police cameras. Similarly, in clause 22.2, by having the mandatory use, we think it necessary that the minister, again not the National Security Council, the minister, upon the advice of the NSC, after consultation with the Commissioner of Police and the Chief of Defence Staff, shall make standing orders for the mandatory use of body-worn cameras in zones, which shall be published in the Gazette twice in 2 daily newspapers in wide circulation and on the websites of the TTPS and the Ministry of National Security. We do that to make sure that there's certainty of the law, both for those who are actively using the body cameras and for those who wish to access it as persons who allege that they're victims of certain circumstances in zones. We also propose that we insert a new clause 22.3, that in addition to such other compliance required of police officers and members of defence force, that captures the language for police service regulations, police standing orders, that the Joint Command and every member of the Joint Force shall comply with the standing orders. And therefore, the tail end of that is to now say that, notwithstanding that they may be charged with an offence under any other written law, that a person who commits a breach of subsection 1 commits a disciplinary offence. So we think it a must-have situation that for any zone of special operation, there must be a mandatory use of body cameras, and that there must be a mandatory code of conduct and standing orders, which is published, and that there be offences kept and preserved for breach of these laws, including disciplinary action. Those are our submissions on clause 22. Thank you, Mr. Chairman.
Attorney General.
Chair, there's already, as I understand it, a mandatory standing order on the use of body cameras. The difficulty is that I'm not as sanguine as my friend, that there are 2,000 working body cameras, but I agree wholeheartedly and unreservedly that body cameras should be worn and that we should take steps to ensure that they are worn by persons within the group. So on this, I will wholeheartedly consider this matter.
Okay.
Mr. Chairman.
A question.
Before Dr. Murray.
Mr. Chairman, I listened closely to the Attorney General's response. Is the Attorney General willing to give an undertaking to this committee that he will delay implementation at least until such verification can be achieved that there are sufficient body cameras for all officers concerned.
I am loath to give an undertaking. I have stated my position. As you know, if I give an undertaking, that is that is something that brings certain consequences into play. I do not now know what is the state of the police service and their body cameras. I do know from where I sit that there was a dispute, contractual dispute, with respect to this issue. I'm not sure if this is a small country, and I'm sure that members on your side might know more about this than I do, but certainly body cameras should be worn by police officers. I cannot give an undertaking on it.
Mr. Chairman, I beg your indulgence. Sorry, I neglected to complete my amendments. There was also an amendment to Section 22(2)B and 22(2)D. In Section 22(2), it states that the Chief of Defense Staff and the Commissioner of Police shall establish the protocols and procedures for the use of body cameras. And 2B states that they can decide the categories of persons who may access the data collected and in what circumstances. So I'm proposing an amendment that these categories of persons must include the Police Complaints Authority, the Police Service Commission, branches within the Trinidad and Tobago Police Service that investigate police officers, such as the Police Complaints Division and the Professional Standards Bureau, and also restricted access to the Ombudsman and the Director of Public Prosecutions. So I just wanted those to be explicit in the law and not implied, so that these authorities could not be denied access to the data. As far as Section 22(2)D goes, I believe the Attorney General alluded to the fact that there are departmental orders already in place for the use of body cameras. So I just wanted 22(2)D to state that the body cameras must be used in accordance with those departmental orders. I think there's a Departmental Order 167 that refers to the use of body cameras. Thank you.
AJ?
There is no difficulty. They must wear there are standing orders. They've been enforced since, I'm told, August of 2017.
Yes, that's correct.
And with respect to the Director of Public Prosecutions and the Police Complaints Authority, I think that they would already have, certainly the Professional Standards Bureau would have access to everything that the police has. And there would be procedures for the Police Complaints Authority to get a hold of it. I'm not sure that legislation is required for that, but again, we are ad idem on it. I don't think that you need to legislate for that.
So it's implied in the law that they will have access. So they cannot be denied access to the data, because it says here that the Chief of Defense Staff and Commissioner of Police shall establish the protocols and the procedures to provide for the categories of persons that may access. So as long as this does not prohibit access, then it's fine.
Well, yeah, I don't think that the protocols that may be established can override the existing law.
Okay, thank you.
The question is that clause 22 be amended as circulated by Dr. Amery. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 22 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 22 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 22 now stands part of the bill.
Clause 23.
The question is that clause 23 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, clause 23 is the requirement for ballistic signatures for ammunition by the TTPS and the Chief of Defense personnel, unless the Chief of Defense Staff or the Commissioner of Police determine otherwise.
Can I just say it's ballistic signature and ammunition?
Thank you. I accept the Honorable Attorney General's guidance. Forgive me, I'm focusing on the mischief in my mind, which is the ballistic signature. In looking at that, the caveat that applies to the requirement that the ballistic signature and ammunition assigned shall be registered with the Forensic Sciences Center prior to conduct is that the CDS or the COP may say no. We propose that that wording be deleted and that it is mandatory that ballistic signature and ammunition must be registered with the Forensic Center. We believe that that is to provide for the balance and concern as to tracing, particularly in killings that may be not accounted for, and we're quite aware that the population is concerned about these issues. So those are our submissions, Mr. Chairman.
No, I just said I'll consider that a useful point.
Okay, the question is that clause 23 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 23 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 23 now stands part of the bill. Okay, Honorable Senators, there's a procedural motion that we have to proceed with, and we shall now resume to accommodate that procedural motion. Business.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honorable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The business of this Honorable Senate will continue until its completion at hand. The Senate will now resume in committee.
Clause 24.
The question is that clause 24 stand part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. In keeping with our philosophy behind amendments that members of the joint force who exercise these powers ought to be members of the police force, we propose 3 amendments to clause 24 so that we're specifically ensuring that it is a police officer who is a member of the joint force who may do the respective things that are required. The rationale has been set out in the previous submissions that we've made, and we rely upon those. Thank you, Mr. Chairman.
Attorney General, you have any? Okay, I'll put a question at this time. The question is that clause 24 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 24 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 24 now stands part of the bill.
Clause 25.
The question is that clause 25 now stands part of the bill. Senator Alwari, SC.
Thank you, Mr. Chairman. Mr. Chairman, in seeking to provide constitutional support for this bill, we specifically looked at the Independent Commission of Investigations Act 2010, Act number 12 of 2010 of Jamaica, otherwise known as INDICOM. INDICOM is essentially the Jamaican equivalent of the Police Complaints Authority. It is, by its structure, a commission of Parliament known as an independent commission, and it proposes that a commission is to be appointed by the Governor General in consultation with the Prime Minister, and after consultation with the Prime Minister and Leader of the Opposition, i.e. similar to our Section 80 of the Constitution, where the President, substituting General, the Governor General, can act in his or her own discretion. That's the first point. We propose that, as opposed to the bill's suggestion that the Prime Minister and Council appoint a committee called the Social Transformation Committee, that it should in fact be the President acting under Section 80 of our Constitution in his own discretion, in this case, her own discretion. The second aspect that we go to in borrowing from the INDICOM legislation in Jamaica is that the persons that populate this independent commission in Jamaica, as appointed by the Governor General in Jamaica, actually come from both sides of the House. In Jamaica, you will see that the leader of government business in the Senate, the leader of opposition business in the Senate, the leader of government business in the House, the leader of opposition business in the House, etc., are members of the committee who ultimately then choose who the independent commissioners are. We propose these amendments to provide the footing that the council that is to be prepared under Section 25 of this bill is not viewed to be merely an extension of the executive arm of the government. Instead, it provides the opportunity to have a degree of independence in the population of an independent committee. And it is for those reasons that we propose the amendments to Clause 25, borrowing from the precedents that I have referred you to, Mr. Chairman. Thank you.
Attorney General.
Chairman, our constitutional structure, this is a question that we've been going around and around this evening. The powers of the President are set out in Section 80 of the Constitution, 81, 2, and 3 in particular. 81, that sets out the cases in which, under the Constitution, the President is required to act in his own discretion after consultation or in accordance with the advice. It is only in 83 that you get a delineation of 3 circumstances in which the President can act by himself. That is the power to appoint the Prime Minister, powers under Section 78, and an exercise of the power to appoint the leader of the opposition. Now, it is true that there are provision, there may be provision made in other law. We don't think that that is necessary here, and again, in other words, we don't agree.
The question, I'll now put a question. The question is that Clause 25 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 25 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 25 now stands part of the bill.
Clause 26.
The question is that Clause 26 now stand part of the bill. We have Dr. Atz, Senator Dr. Atz, Dr. Murray, and those are the 2 in Clause 26. Dr. Atz?
Thank you, Chair. At this time, I wish to withdraw my proposed amendments to Clause 26.
Dr. Murray, the floor is yours.
Thank you, Mr. Chairman. My amendment is simply to propose a new sub-paragraph to 26.1, which outlines the functions of the committee, and that is to include that the committee should hold its first meeting within 1 month of being constituted, so that there's a timeline within which the committee must meet. Thank you.
Attorney General, do you have any intervention?
Within 1 month of being constituted, and they need to be constituted within 5 days of a zone being declared, yes.
That's an interesting point. I'll consider that as well, Chair.
Okay. All right. The question is that Clause 26 be amended as circulated by Senator Dr. Murray. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 26 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 26 now stands part of the bill.
Clause 27.
The question is that Clause 27 now stand part of the bill. No, let me just repeat that. The question is that Clause 27 stand part of the bill. Senator Alwari.
Mr. Chairman, my proposed amendment here was in keeping with the amendment that minister be defined, just to remove these words, and we've already ruled on that. So the rationale is really so that we could tidy up the bill's language.
The question is that Clause 27 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 27 stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 27 now stands part of the bill.
Clause 28.
The question is that Clause 28 stand part of the bill. Senator Vieira, SC.
Thank you, Chair. My amendments were looking at the question of parliamentary review. It seemed to me that the initial implementation phase carries the greatest risk of abuse, misunderstanding, or unintended consequences. I believe more frequent early reviews and quarterly reporting would allow rapid correction of unintended consequences. It will build public trust and confidence during the initial implementation, and transparency will protect both civilians and law enforcement officers. If these powers are truly necessary, Parliament should be willing to renew them, and if not, they should expire.
Senator Michael de la Bastide.
Chair, I withdraw my proposed amendment. Thank you.
Mr. Chairman, I was thinking pretty much along the same lines as Senator Vera, but I had put it quite simply that we start reviewing the Act within 6 months, because by then we would have obviously realized that we're in conflict with the children's law package, we're in conflict with the AJIPA, we're in conflict with search warrants, a number of things. So the sooner we started tidying up the law, the better. So my proposal was for 6 months.
I would seriously consider Senator Vera's suggestions. I think that Senator Arawi is pretending not to know that AJIPA is dealing with administration of justice, and while the concepts in some regard are useful, that it really has very little to do with what is in fact a law enforcement and social transformation exercise.
Thank you, Mr. Chairman. Just to conclude my position. Thank you, Honourable Attorney General. Of course, I was speaking about the fact that you may be charged for an indictable offence, and therefore it is very relevant, just like the Summary Courts Act. So I thank you for the opportunity to clarify that.
All right, the question is that clause 28 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. I think the noes have it. The question is that clause 28 be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. I think the noes have it. The question is that clause 28 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 28 now stands part of the bill.
So we're going to start considering new clauses. The question now is questions of new clause by Senator Larry be read a second time. If it's not read.
It's called new clauses that have been proposed. The question is that new clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. No. The noes have it. New clause 4 will not be read a second time. So we go to the next one. Next one. New clause 6A be read a second time. This is by Senator Dr. Malinats. Those in favor say aye. Aye. Those against say no. I think the noes have it. New clause 6A will not be read a second time.
New clause 10A.
The question is that new clause 10A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 10A will not be read a second time.
New clause 11A.
The question is that new clause 11A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 11A will not be read a second time.
New clause 26A.
The question is that new clause 26A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 26A will not be read a second time.
New clause 28A.
The question is that new clause 28A. Right. New clause 28A as circulated by Senator Anthony Vieira, SC. The question is that new clause 28A as circulated by Senator Vieira be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28A as circulated by Senator Vieira will not be read a second time. The question is that new clause 28A as circulated by Senator Alwari be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28A as circulated by Senator Alwari will not be read a second time.
New clause 28B.
The question is that new clause 28B be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 28B will not be read a second time.
New clause 29.
The question is that new clause 29 be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 29 will not be read a second time.
Now we move on to the schedule.
And the schedule stands part of the bill, right?
Yeah, the question is that the schedule stands part of the bill. Stand part of the bill.
Go ahead.
The question is that the schedule now stands part of the bill.
The question is that the schedule stand part of the bill.
And then we have senators.
Those.
We have Senator Dr. Hans, Senator Vieira, Senator Etienne, Senator Amery, and Senator Browne.
I'm reminded we have amendments from the following senators: Dr. Marlinats, Senator Anthony Vieira, SC, Senator Etienne, and Senator Dr. Marie, along with Senator Alwari. In that order: Senator Anthony, Senator Dr. Marlinats.
Thank you, Chair. In looking at the schedule for the Social Transformation Committee, at item 1G, it was listed a representative of the ministry responsible for Social Security, and I wondered if that should be a representative of the Ministry of Social Development and Family Services. At 1H, it read a representative of the ministry responsible for national security, and I wish to suggest that that be replaced by a representative of the Ministry of Homeland Security. At 1J, on the schedule is presented a representative of the ministry responsible for economic growth, and I wish to suggest that that be replaced by a representative of the Ministry of Planning, Economic Affairs and Development. I wish to, with respect to 1R, which reads, a person who the minister is satisfied is a representative of a bona fide community group active in the zone. I wish to suggest that that be replaced by a representative of a bona fide community-based organization operating within the zone for a minimum of 3 years and who is nominated through a transparent and documented process and approved by the committee.
Senator Anthony Rivera, SC.
Thank you, Chair. My amendment was aimed towards amending the Social Transformation Committee to strengthen civilian oversight. And basically, I was piggybacking on the recommendation that had been made by the Law Association. While the committee includes community representation, it does not formally embed parliamentary oversight at the local level. So by making the constituency MP an ex officio member, you're strengthening civilian oversight, you're improving community trust, we are ensuring that Parliament will remain connected to lived impacts. It does not interfere with operations, and the perception of military or executive overreach would be mitigated. Thank you.
Etienne?
Referring to the persons that would be on the Transformation Committee, my opposed amendment was that it will be someone that the minister will choose that will have a disability. And in item X, from a bona fide NGO. Reason for this is because many times you have people that work alongside persons with disabilities, and they are qualified as well. However, they are not the person that living with the disability, and even though they may give recommendations, sometimes the recommendations would not be accurate. Also, people tend to choose someone without a disability that works alongside the person with the disability. So to strengthen it and to cover the persons with disabilities, my recommendation is that the minister will choose someone that has a disability from an NGO, a bona fide NGO. And the reason why I asked to expand it from National Center for Persons with Disabilities is because you may have 3 or 4 zones, and how could that one NGO cover persons that are qualified to be on the committee? So my opinion is that you expand it out to other capable and qualified NGOs so that they could also have someone that will be chosen from their organization to serve on the committee that has a disability.
Okay, thank you. I recognize Senator Jeremie.
Thank you, Mr. Chairman. My recommendation comes out of the recommendations following the review committee in Jamaica after the 3 years of the zones of special operations in that country. And they recommended that if a committee member was absent for 3 consecutive meetings, that they should be replaced by another person. We heard during the debate that many committees are constituted and persons don't attend regularly. So if the Social Transformation Committee is to be effective, then there should be regular attendance by the members constituting the committee, and I therefore recommend that if a member is absent for 3 consecutive meetings, that they be replaced. Thank you.
Thank you so much, Mr. Chairman. Mr. Chairman, borrowing from the INDICOM structure, that is the Independent Commission of Investigations Act 2010 of Jamaica. I've proposed that, in keeping with the amendments that I offered in respect of Clause 25, which we've dealt with already, for harmony, that it's the President, after consultation with the Prime Minister and Leader of the Opposition, may at his own discretion do these things. That is to take avail of the opportunity that the President has in Section 83 of our Constitution. I also proposed, similar to the Jamaican inclusion, that representatives of the Leader of the Opposition be included there. I note in some of the language of the bill, for instance, in 1R and S, that we refer to someone who, a person who the minister is satisfied is a representative. A person who the minister is satisfied lives. I don't know who that minister is, because the amendment that I propose that the minister be included in the definition section has been rejected. So you'd need some clarity as to who that minister is. So those are our submissions. It is to improve the constitutionality and balance of the legislation in keeping with precedent and the Constitution. And with respect to R and S, there certainly is need as to who this minister is, because there's no definition of minister.
Senator Amery Browne.
Thank you, Mr. Chairman. I don't know if the Attorney General is ready to proceed, but understood.
Right on, Senator Browne.
He's asked for a moment, Mr. Chairman. Ready? Chairman, thank you for the forbearance. This is not by way of scripted amendment, but requesting clarification from the Attorney General on the record with respect to Schedule 1B and C. 1B contemplates a zone that may straddle multiple constituencies and is scripted accordingly. 1C does not contemplate zones that straddle more than one regional corporation. Is this a matter that the government has considered? And if so, why have they not imported the language from the second portion of 1B into 1C? That is, if the zone is located in two or more regional corporations, the mayors or their nominees of the borough or chairman or their nominees will be included in the committee. So it's just for the clarification on the record. Is this something the government has contemplated?
Yes, AJ, respond to those people, all those senators.
The points made by Senators Vera, Atz, and Etienne, those are matters that we would give serious consideration to. I'm not sure that I understood the acronym National Center for People with Disabilities and the distinction between the mischief there, why persons nominated by that entity could not represent persons with disabilities. But in principle, we would give serious consideration to that, subject to me having some sort of clarification on what exactly is meant by that. Senator Murray's point on the giving up of a seat, a place, if you miss, I mean, that is standard proper corporate governance now, that if you don't attend a certain number of meetings, you aren't interested, and that a replacement for you should be found. I don't see a problem with that, so that too I can agree with in principle. Senator Rawi's point on the President and the Prime Minister, I think we've spent a lot of time discussing that back and forth. So regrettably, again, I must disagree with you on that. There's one other. Oh, the names of the ministries. Those are things that change from time to time. So whereas I can see, and this is perhaps a good example of why we need to revisit, we will need to revisit this. Now, there is now no Ministry of National Security. There is a Ministry of Homeland Security. We do not know what the position will be in a year's time, in 6 months' time, and some of the other ministries that you referred to as well. I'm not sure about the Ministry of Social Security, if we've ever had a Ministry of Social Security. But if we can find, so I agree with the point in principle. If we can find a generic expression to cover.
Perhaps it is through the chairman, perhaps yes, a descriptor as opposed to a specific name.
Correct.
Because consistent with your point, Attorney General, at 1M does specify representative of the ministry, so perhaps a descriptor as opposed to specifying.
We run into problems as it is now with labels in different pieces of legislation. I have portfolio responsibility for something which is described to be the responsibility of the Ministry of National Security.
That's the way the section is drafted.
Say again? I don't have sole responsibility for it, but I do have some responsibility for it. I'm sure you sleep comfortable at night knowing that. Exactly.
The way the section is drafted, wherever we say the minister, it has to be the Minister of National Security, because that's how it flows.
Yeah. So, Chair.
Senator Browne asked a question.
Senator Browne's question, Senator Browne, I'm sorry, your question was lost.
Rationale for not contemplating in C that a zone can also cross multiple regional corporations. In B, the government has contemplated zones crossing multiple constituencies.
Well, I mean, in principle, I would think that a zone would be determined by prescriptive criteria. So if you have, to use the language of the Act, rampant criminality, gang-related criminality, then that would be whether it crosses a line or a street or something of the sort. So I'm not sure that I'm answering. I see you. Okay.
Not wishing to delay the Attorney General, Mr. Chairman, but if I could point you to 1B in the schedule, where the Member of Parliament of the constituency within which the zone is, or if the zone is located in 2 or more constituencies, plural, the Members of Parliament. And then I take you to C, the mayor, so these are the members of the committee, the mayor or his nominee of the borough or chairman.
So I'll seriously, I see what you see. I'll take a look at it seriously.
Honorable Senators, I'll now have to put a question on each. The question is that the schedule be amended as circulated by Senator Dr. Marlene Atts. Those in favor say aye. Aye. Those against say no. No, the noes have it. The question is that the schedule be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Etienne. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Dr. Desiree Marie. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule be amended as circulated by Senator Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The schedule now stands part of the bill. All right.
The preamble.
The question is that the preamble to the bill be approved. Yes, Senator Alwari, you have an amendment. Yes.
Mr. Chairman, for the record, I propose that the preamble be amended to include the fact that the bill, in our respectful view, requires a 2/3 majority and a 3/5 majority. The 3/5 majority is already included in the bill, so a collection of voices will require us today to go for 3/5 support. In our respectful view, Section 54 of the Constitution is, in fact, requiring a 2/3 majority, and we ought to be saying that this act shall be construed as altering the Constitution, which is the language one normally uses. The rationale for this is, specifically and succinctly, that this bill in Section 14, Clause 14, proposes to give police powers specifically to members of the Defence Force. The giving of police powers to members of the Defence Force means that the members of the Defence Force are going to be subject to the general and specific directions of the Minister and also the Defence Council, again chaired by the Minister. When we look to Section 54(4) of the Constitution, and we see that Section 54 calls for special majorities at 2/3 because of a number of circumstances, the language which I wish to put on the record at Section 54 is as follows. Section 54 of the Constitution, the marginal note is alteration of the Constitution. 54(6), says, in this section, references to the alteration of any of the provisions of the Constitution or the Trinidad and Tobago Independence Act 1962 includes references to repealing it with or without reenactment thereof, or the making of different provisions in place thereof, or the making of provisions for any particular case or class of case inconsistent therewith, to modifying it and to suspending its operation for any period. The intrusion into the Constitution that I'm specifically referring to occurs under the rubric of the provisions of Chapter 9 of the Constitution, specifically the Service Commissions, and the fact that Police Service Commission in Section 122 of the Constitution is established, and that the Police Service Commission in 123 deals with the powers that they have, in particular to discipline the police and the Commissioner of Police and the Deputy Commissioner of Police. And Section 123 of the Commission gives the Commissioner of Police power to manage police service. So the Commissioner of Police manages lower ranks, the Police Service Commission manages the Commissioner of Police and the Deputy Commissioner of Police. The Service Commission is an independent body which keeps the separation of powers position alive for us. Therefore, in seeking to have the Trinidad and Tobago Defence Force have, by express mention in Section 14 of this law, I don't know if Senator Swaratson has something to say. Oh, yeah. Go and take a break. You'll be all right. So, Mr. Chairman, in dealing with a serious issue of the Constitution, because we are not tired to deal with the constitutional rights of citizens, in seeking to have police powers expressly given to members of the Defence Force, it is for us clear that there is a modification of Section 9 of the Constitution and that a two-thirds majority is required by Section 54(6) of the Constitution, as I have read it out. Mr. Chairman, it is for this reason that the 2017 bill, which came under my tenure as the Attorney General, had Clause 4 of that bill saying that this act alters the Constitution. For the benefit of the record, I'm putting these positions on record in aid of the rule of pepper and heart for interpretation and for constitutional challenge. Perhaps Senator Swaratson would be satisfied to know that there's a reason that this is being put on the record. So, Mr. Chairman, these are the submissions as to why this bill requires not only a 3/5 majority, but a 2/3 majority, and why the law should state that in the preamble and in a new clause 4. For the last point now, the position in Jamaica, in their constitution in Section 13, both in the chapeau and in the choiseul of Section 13, there is a material difference in their constitutional arrangement. So the Jamaican laws never have the constitutional prescriptions that we do because they have exceptions for public interest expressly stated in Section 13 of their constitution, which we do not have. Those are our submissions for the record, Mr. Chairman. I accept the Honourable Attorney General has already addressed that he does not agree with our submissions, but I've made them for the benefit of the record. Thank you.
No. General, you have any comments?
That's what other people should be saying, boy.
Chair, not only do I not agree, I think the Privy Council has ruled on this and definitively on it, and I disagree. The Privy Council disagrees as well.
All right. The question is that the preamble be amended as circulated by Senator Faris Alwari, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that the preamble to the bill be approved. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The preamble to the bill is approved. The question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The Honourable Attorney General.
Mr. President, I wish to report that the law reform zones of special operations, special security, and community development measures Bill 2026 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the law reform zone of special operations, special security, and community development measures bill 2026. Those in favor say aye. Those against say no. I think the ayes have it. The Honorable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety with certain geographically defined areas of Trinidad and Tobago, and for other related matters, be now read a third time and passed. Those in favor say aye. Aye. May I remind colleagues before we go to that part, this bill requires a 3/5 special majority vote, and the clerk will now conduct a division.
Mr. Alaha?
Yes.
Mr. Jeremie SC?
Yes.
Mr. Roberts?
Yes.
Dr. Swarat Singh?
Yes.
Mr. Maharaj?
Yes.
Mr. Batiste?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Ms. Charles?
Yes.
Mr. Zakur?
Yes.
Mr. Smith?
Yes.
Mr. Naked?
Yes.
Mr. Rashid?
Yes.
Dr. Browne?
No.
Mr. Al-Rawi SC?
No.
Mrs. Roberts Rajman?
No.
Mr. Cummings?
No.
Mrs. John Bates?
No.
Mr. Boodhu?
No.
Mr. Vieira SC?
No.
Ms. Choate SC?
No.
Dr. Axe?
No.
Mr. De La Bastide SC?
No.
Ms. Jones Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
No.
Mrs. Lalit Etienne?
No.
Mr. McNish?
Abstain.
Mr. President, the results of the division are as follows. 15 senators voted for the bill, 14 senators voted against the bill, and there was one abstention.
Honorable Senators, as a result of the division, 15 members voted for the bill, 14 members voted against the bill, and there was one abstention. The bill has not been approved. The Honorable Leader of the House.
Mr. President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to a date to be fixed.